Picture this. If I can picture it. That's the problem. All right, picture this. A 7-month-old baby left safe in a car seat on a stranger's lawn, 40 miles away. Her mom, grandma, aunt, and 15-year-old uncle are found shot dead. The man police arrested for it, Austin Drummond, who was basically family to them, dating one of their relatives. But here's the twist. From jail, Drummond swears he's innocent, that he was forced to defend himself. He says he had no reason to hurt the people he considered family, but they discovered he was working with authorities as a confidential informant and they attempted to murder him. He claims he ran because he was scared, especially because his cover was blown. Now he's fighting for his life, pleading not guilty, and just asked to represent himself in court. Is he a cold blooded killer or is something else going on? Let's find out. Good morning, everybody. It is just me, your host, Ali Mata. A little bit of a communication issue here with my husband. So that was my cold opening. But what I also didn't do, and I'm going to ask all 172 of you maybe to do it for me, is I forgot to go on X and even share that this live existed in the world. So, we'll have to see what happens. You guys know how I hate looking at my own face, so big and giant. So I'm going to put up Action News, just hoping that they are about to go live with this thing while I wait for Bob and or Tracy to let me know if they found it somewhere else, because as of this moment, it is not up on their stream. Whew, there we go. That's better. That's the way I like it. Also, I was trying to watch my niece's graduation from YouTube. And of course, as soon as they get, as soon as we had to start this, um, is probably when she'll start walking. And then right after, okay, no, right after I got on with you guys, my phone just decided to be a complete jerk off and here it is, and take me out of it altogether. So I couldn't even be watching for when my sister texts me and says, okay. But I got her right there in the background because I love her so much. Congratulations, Jerry Reese Pollard. You did it. All right. So I don't know, y'all. We got 3 people waiting. Let's just see what happens when we click on it right now.
What they have shown us.
No.
But again,
doing like
to have the
regular
famous
news.
Bill Nye the Science Guy come to Bailey's
So, oh no, I let it
station
play,
in Collierville.
but mute it just in case this somehow at 10:30 is going to magically convert to it. I'm trying to go to their Facebook page on my other screen here. Because the court clerk, she gave me all the possible stations it could be. And station 5, which is what we're looking at now on YouTube, Action News 5 posted something on their Facebook page that they will be live streaming it. So Action News 5, let's just get to their, see, this is the official Facebook page. Da, 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 da. I don't know. We're on their page. I see nothing. But to tell you the honest truth, I have no idea how to even work Facebook anymore. I mean, I haven't been on here in so long. So I see like, oh, I see various posts. Tune in at 10:30 on all platforms, including Action News 5's website and app. All right, that's what I'm going to do, people. And they said it but I hate Facebook. I don't wanna have to stream it from Facebook. Let me try the app. And I said that because Tracy's letting me know in the background here. They said it'll be on Facebook. Action wait, what is it? What did I say it's called? Action News 5. Okay. I didn't know if it was like 5 Action News. My husband's in so much trouble with me for making me do this by myself. Y'all know how I hate that. Watch live. All right. All right. We're in. Thanks, Trace. Yes, Tracy helped me this morning because I went to all the news stations' YouTubes and I'm like, I see nothing. She's like, did you check Facebook? Like, no, can you? And she did. And she found it. And on that Facebook post, it also said they will be. Oh, so it is what I was watching on. It's that regular. So it is this, apparently. I'm gonna keep an eye out on their website page too, but it looks like it's the same thing as we're looking at right here. No, this one is now showing like that, and their Facebook page is still showing that lady that was on. Oh, are we not live? Is that why? I don't know. This thing's showing commercials and everything. Maybe we will watch it on Facebook. Oh no, we're watching it on YouTube. So it is showing the same thing. It's showing this guy with the weather. All right. Okay. We found it, people. Disaster averted. We did it. We did it. No problems over here. Allie's got it all under control, babe. Let's see who is here. I can say good morning to some people. We got Sharon, who, by the way, I was logged in as Bob on. They're doing criminal justice now. She's in psychology. Maybe they're going alphabetical because it started with accounting. Okay. So I was logged in as Bob on YouTube last night or early this morning, one or the other. Um, and I was like, oh, somebody did the little thingamajigs. What do you call those? The timestamps of where we're at. And he's like, yeah, that's our mod. She does it. So thank you, Sharon. Appreciate it very, very much. So that we appreciate it actually came from me. Bob was already fully aware of all things going on. Gina always gives her hello, hello, beautiful humans, just like Bobby. Happy Friday. Yes, happy Friday. So let me just we'll talk about this case a little bit, is what we'll do. So Austin Drummond has, in fact, despite my confusion on the last live, indicated that he acted in self-defense. His assertions of innocence is because he's innocent of the crime accused, and that these people found out he was acting as an informant, and that I guess they heard that he was somehow allowed to keep some money, had some money stashed. I wish we had time to play his statement, um, but I didn't think to start earlier because I was just so unsure about if we were going to find this. Let me just make sure there's nothing different happening on the website. No, they're still showing this. And on the website, it literally says the words "on now" at Arizona family original with Yetta Gibson. It's not what I see. So, hopefully, like, what I see is still this guy doing the news. And when I click on the other thing, it's something different. It's weather. So, dude, now I clicked on it again and I got a commercial. I got that first commercial. Let's just make sure there's, well, oh boy. Oh boy. Okay. Yeah, this is what we got. This is what we got. I'm gonna try the chat over here. Will this stream, let's see, be the same stream. Oh, wait, maybe this is happening right now. Okay, we did it.
Digital desk. Austin Drummond is in court here in Lake County, Tennessee. He is the man accused of killing a family of 4 and also abandoning a baby about a
saving
year
a
ago.
baby,
Let's
rescuing
listen
a
in,
baby.
for the latest.
How about June 22, Mr. Huffman? Mr. Swift, that work for you as well, sir?
Oh, great. They're continuing it?
One? Okay, great. And we'll either set or dispose that day, okay?
Oh, maybe they're talking to another
Very good,
lawyer.
thank you.
Okay. Dealing
Let's
with
go
another
ahead and,
case.
he's-
I was like,
Mr.
oh,
Drummond
shit.
is in the courtroom. State versus Austin Drummond, 25 CR 11185. Have a number of matters to take up. I want to at least start. I don't think we'll finish it, but I at least want to start, Mr. Drummond, with your motion to waive your right to counsel, pardon me, and exercise your right to self-representation. Court's read your motion. There are a number of things we need to do before the court can consider your motion. I'm going to hand down to you a document that is called waiver of the right to be represented
Wow.
by counsel.
I can't believe
It's
it, guys.
essentially a questionnaire. You're being asked to answer a number of questions. It's an 8-page document. And then there is once you get to the end of it, there is a page for you to sign in writing that you desire to waive your right to counsel in this matter there. Hand it to Mr. Huffman and Mr. Ferguson first. Let them look at it and make sure that what I'm saying is correct, and then they can hand it to you, Mr. Drummond. Do you have a pen, sir? You're gonna need an ink.
You're going to need a pen. That was Bob coming down to be like, hey, Tracy sent you the link to Facebook. Like, I found it on YouTube.
So what I want you to do, take your time, read through that, answer the questions if you will. And then we'll come back to that in a few minutes, okay?
This is a horrible decision as far as I'm concerned by Austin Drummond.
While you're looking through it, if you have any questions, we'll stop the other matters we're doing and I'll answer your questions as best I can, okay?
But his concerns,
There are other motions pending, and today was a motion hearing date.
there's also a motion to change venue.
Also, before we get started, there are a number of motions which have been filed by Mr. Drummond pro se. Court's not able to take those motions up
pro
today
se.
simply because motions that were to be heard today were required to be filed before. Prior, there was a deadline, I think was May 1, for motion filings for motions that will be heard today. I anticipate we'll set another motion date with a motion deadline for both sides and see where we are. You know, in a case like this, there are generally 2 or 3 motion hearing days before we're able to get to setting the matter for trial.
So I don't know. It sounds like the judge is intending to still take up the motion scheduled for today, even though he's asked to represent himself.
You'll need a minute to go through that before we hand it off to Mr. Drummond.
Yes.
Before he resolves the motion to represent himself, and because he said something like, I don't think we'll get through it all today. So I don't know. Maybe he's not taking it up. But
I've revised the questionnaire a little bit in light of the Court of Criminal Appeals decision just a
we're at
couple of weeks
political
ago.
science, guys.
Actually,
Psychology's
1 week
next.
ago, May 4th,
Psychology.
in State versus Christopher Feeder, that Henry County case at the Court of Criminal Appeals, decided that modified the procedure just a little bit for pro se representation. You want a copy of the
They zip
questionnaire?
through these fast.
No, sir, I did not. I brought one actually, and then didn't give it to you.
What?
If you're just joining us here on Action News 5's Digital Desk, you are watching live coverage inside the courtroom of Lake County, Tennessee. Austin Drummond's in court, accused of killing 4 family members in Lake County and abandoning a baby. He wants now to represent himself. He says he's fired his attorneys and wants to represent himself in court. There's a number of other motions the judge is considering right now. We continue to listen in here on Action News 5's Digital Desk.
So I'm like watching both screens. He believes that his lawyers aren't doing enough. They're not responding to him enough. He has not seen them, at least as of our last live. And as far as I've been informed, continuing, I think, until today.
Again, our photographer is there inside the courtroom as the attorneys and the judge in this case in Lake County, Tennessee, review some of the documents that accused killer Austin Drummond filed in court right now. Let's listen in.
We suggest changing that question to a capital qualified jury.
I'm happy for you to write it in. And that's a fair.
What? They just
You can also see a number of different law enforcement inside the courtroom right now as the attorneys confer along with the judge on some of the motions that have been made in court. Let's listen in.
Let's look at the motions that are scheduled for hearing today. The first one I've got is the state's motion for a protective order for discovery, which was previously granted by the court. There's been a motion filed, Mr. Huffman, I think you filed a motion to modify the protective order. Is that right?
That's correct, Judge.
Do you have a proposal as to how that would work?
coming up.
Right now, Mr. Drummond does not get to keep a copy of the discovery because of the history of publicizing. Creates a lot of problems for the case. Number one, it creates a lot of unnecessary publicity. It is difficult for the families of the victims, and it's really interfering with the orderly process in this case. So how do you propose we modify that in order to not have a problem?
Well, Your Honor, I think I've actually got the second motion, which is to review the statutory requirements to have him be remanded back to a local jail. They kind of go hand in hand. The biggest issue that we have right now is being able to effectively communicate and coordinate with Mr. Drummond. Where he's being housed now, it's extremely difficult to be able to even give him copies of discovery to review while we're there. Have Ms. Ferguson here, an investigator, has been there a couple times, and the issue that we have is the way TOC is allowing the in-person visitation is conducted through glass, and it's very difficult, and we've got to control.
Is she going to testify any differently from her affidavit?
I don't think so, Judge.
You've seen the affidavit? Yes. I've seen the affidavit.
So that's presenting a big challenge. We are able to meet by Zoom, and we can screen shares. But as far as being able to really have meaningful opportunity to review that discovery, it's not feasible, especially with the Zoom timelines and the way we have to coordinate with staff.
What is it about the Zoom that prevents you from speaking with him?
Well, the Zooms are going to be limited in nature because they have to have a staff member although not in the room, right outside of the room, as opposed to in the visitation area. And so they're limited in scope and length when it comes to visiting. So we are able to communicate with them, but it's a short burst. Again, we can show him with screen shares, but that's going to be a very limited time frame for him to review the documents. And of course, he can't retain them to review them at any length. So that's really a very big, significant challenge, especially with the 6-minute right, to.
And you think that would be fixed if you had better access to him? Is that what you're telling me?
Absolutely.
Even if he doesn't get to retain copies of the discovery?
Yes, it would obviously be more advantageous if he could retain copies of the discovery. My suggestion to the court would be to have some kind of a modification of that order where the documents are available to him in the prison, but they would still need to be controlled from the standpoint of not being able to then take it back to the cell. For instance, he can go to the law library and check out the materials, review it, when he's able to have that come or whatever, but just not being able to take it back maybe to his cell.
Is that available where it's presently housed? It's not, it's probably not available in a local jail.
I'm not certain, Judge. I think there is a law library where he's at, but again, that would be subject to the prison staff being able to get in there to be able to do that. It's just not feasible for him to be able to review. It's voluminous discovery plus videos, and it's a lot of discovery.
You understand what I'm looking for is some reasonable assurance that the materials are not going to also wind up in some sort of published form.
Absolutely.
Publicly published.
And I think that if there was some potential resolution crafted where those materials are controlled, but available for him to take out during the day or whatever, we're not taking back to the cell or whatever. As long as the staff make sure that they control access to those documents, and if they don't go back with him, I think that would be the better alternative. That's the only other suggestion that I could have that would allow him to review his discovery in a meaningful manner, a lengthy manner, because again, it's a lot of documents.
I understand that. I understand that. So it won't be very long.
Yes, just briefly. I mean, our position really depends on what is available for him at Riverbend or wherever he's housed. Obviously, the state files a protective order, a request for protective order, and we want it to remain in place. Our concern is just like the courts, the availability of the public. So whatever possibilities there are at Riverbend that Mr. Huffman has talked about, whatever those are, that's kind of when the state would really know his position, what's publicly or what's available that staff can do to allow him to see his discovery, but also make sure this does not make it out on the internet.
Well, we don't know that. I'd a whole lot prefer to know that information in order to make a decision on the motion to modify. But it may well be worth looking into where we could put it on a checkout basis if the Department of Correction law library at whatever facility he may be at is able and available.
Judge, I've had some good contacts with general counsel through the Department of Corrections. I don't mind starting an email chain with him and Mr. Huffman and Mr. Ferguson, and maybe we can find out what avenues they potentially have, and we can present those to the court at a later time.
I'm not trying to cut you off from putting the investigator on, however, if she's going to testify consistently with her affidavit.
It's best that she testify, Judge. I don't have the court.
And I don't want to cut you out of the opportunity to cross-examine. Yes, sir. Well, I'll tell you what I'd really like to hear before you do that. What I'd really like to hear is that we're past that. We're past the need to publish stuff, the desire to put stuff out in the public that continues to interfere with this case. That's what I'd like to hear. I hadn't heard it yet, but I'd like to hear. So what do you need to tell me, sir? He's going to need a microphone. We get him on the record. Just keep your seat right where you are.
Here we go. He's going to speak for himself.
What do you need to tell me about that issue, sir?
Your Honor, I just want you to know that I have no intention of
You understand the history is inconsistent with that, right?
Speaking directly about the recorded statements.
We don't have to, we don't need to talk about it. I'm just worried about what we do in the future. What's done is done. Let's talk about what we do in the future. And if you're telling me you're past that, it helps me.
Yes, Your Honor, I have no intention of.
You understand that if the court modifies a protective order and something winds up being published out there, number one, I'm gonna find out about it. There are too many people following this matter. I'm gonna find out about it. And number two, it's gonna really cause you a problem. It's gonna delay getting your case tried, which means you're sitting in prison doing nothing. Okay, you understand how that, additionally, and based on history, some of this stuff isn't helpful to you. You know, okay?
Yes. Your Honor.
But thank you for telling me that. Anything else you need to tell me about it?
Yes, just a suggestion. If there's any way to give an order that I be furnished with some type of device or equipment to write and review the documents digitally, I wouldn't be paper copies, but there would be no concern with that.
Okay, thank you for asking me. It's a fair question.
So I'll just pause it there. What he asked, in case you couldn't hear, is if he can be provided with some kind of device or mechanism by which he can watch the digital evidence.
Yes, sir, please do.
Now, the state concern with that is, he's saying today that he will comply with the order.
Right.
You ordered him on one location not to violate a gag order, not to release any information or discovery, and he's continued to violate your order. As a matter of fact, he has done that twice since he's been at River Bend and has been written up twice for violating your order. So, the fact that he says he will not do that does not.
Give him a chance, Judge.
Because he said that before, and has violated these same orders.
Well, I'd rather be hearing that than be hearing I'm gonna do what I wanna do. No, sir, I'm gonna let your lawyer respond. Right now, you're represented by lawyers. I appreciate what you told me, but your lawyer's responsible for this part of this matter. You respond?
Judge, I understand the history of the case. Obviously, the emotions are highly charged here. And given the history, I understand what the court's, why the court has concern and issued the gag order as well as protective order. But that being said, we really need to be able to communicate with him effectively, and he really needs to have a meaningful opportunity to review the discovery and participate in his defense and to work with us. How that has to happen, I understand the court's concerns with things getting out there. Mr. Drummond made a good suggestion. Is, because the documents we have are digital. We can give him paper copies. We can give the prison paper copies, but we can just as easily give him digital copies as well.
I'm not sure whether I have the authority to order the Department of Correction to provide certain equipment. to him.
No, so I wasn't suggesting that. I was saying that if that is a potential, I think that will go a long way to alleviating the court's concerns. It's a lot easier to control a digital tablet or whatever than it is, thousands of documents, which is the alternative that we have.
I see what you're saying.
Yes.
What I think I'd like to do, General, is if you will, make your contact with the Department of Correction with the idea if an electronic device could be provided to a librarian or other person that's available for him to go and look at, in a meaningful way. And that's the whole idea here.
Yes. And I think that that's
Meaningful review.
what we need to figure out is what are the facilities capabilities.
You're right. If we know that, now we'll be back here on the 26th on some other matters. There, maybe, I don't know if you've got, if that's, didn't give you a lot of time, does
Hey.
it? You all have beat you down already.
Who said hey?
I'm sorry.
Okay. Do
What's
you want to do
happening?
it Monday? I don't know.
What? You guys hear that?
Okay, so we're gonna hold a motion till we have additional information about that. I don't know if you can do that before then, so we can at least.
I don't know how.
Dude.
Yeah, I have everything down.
Oh my God.
No, we're gonna deal with that separately.
Buddy.
There's a defendant's motion for discovery and inspection. Are there any issues about discovery at the moment other than the problem with meaningful review?
Yeah.
No, sir, I mean,
What?
we've been working with, Bill Hayes on this. As he's getting these documents, he's getting to us.
Bullshit.
We have a lot of discovery already. There may be additional things coming in, of course, in the case of it's ongoing investigation. So there may be additional documents that are coming in. But Bill Hayes has been very diligent in getting those to us. Right. So there's no other discovery issues that I'm aware of at this time.
I was aware of some.
There's several pending lab reports still, crime lab that we're waiting on. A lot of reports still to be done by.
What about text messages?
There's a defendant's motion for exculpatory material under Brady versus Maryland. Are there any disagreements at this moment about what might constitute Brady material?
No, sir. In fact, I filed that motion initially.
I know. The defendants filed a motion for the production of witness statements related to direct testimony. Looks like the state does not oppose that. Am I right about that?
Yes, sir.
Even though Rule 16, sub 2 does not require it, the state does not oppose that, Mr. Huffman. If you would like to draft an order which would grant that by consent.
How do you want to do this? You want to keep going if he's still going when I'm supposed to shut off? I don't know how.
Motion for records of conviction.
I have this one
And
up.
as I understand, the state does not oppose providing a copy of the records of Mr. Drummond of his prior convictions, but it is opposed as to witnesses. Is that a fair way to summarize your position?
Yes, sir.
Is there any?
Hey, when you submit a help
Mr.
ticket,
Huffman, is there any
you talk about
authority
mic
for
one
the
is
state to provide you
it's
with
got a buzzing sound in it.
conviction records for witnesses?
And your mic's on. What about that one, buddy?
Take the stand with it, of course, that's relevant for cross-examination. There's just a motion to seek that information early, just to prevent any kind of delay at trial.
What do you say about that?
I gotta see the chats on this one. Let's see. How do we do that? Nobody's telling them anything.
I don't think that changes the state's duty. Rule 16 does not mandate it. And as I pointed out in our response, the state's not required to seek the evidence when it's equally available. Public records, they have as much access to it as we do. So I don't think it's anything that just because somebody takes the stand, we then have to turn over a conviction.
Jesus. I can't even
What you're
type.
talking about usually applies to witness statements, which would be available after.
Let me do that
after
all
the
over again.
testimony. However, the state is going to provide those ahead of trial rather than after a witness has testified. I don't think the state is obligated to provide a defendant with copies of arrest records or conviction records of state witnesses. So the motion is going to be granted by consent as to the defendant, but denied.
Now
as
they're all
to
chiming in. Thanks,
state
guys.
witnesses. Mr. Hayes, will you prepare an order?
Exactly. Oh, it's you guys. The virtual juror chimed in. Mic one isn't the only problem.
Defendants filed a motion for hearing on prior convictions and bad acts. If the state does not oppose the motion, the court is going to grant the motion and comply with the procedure set out in the rules of evidence 4034 and 608, 609. We'll look at all of that jury out as it.
Okay, you are watching live
Oh.
here on Action News 5's digital desk. Austin Drummond in court. He's accused
Well,
of
stop
killing
talking
4
over the
members of a
judge.
family and abandoning a baby last year in Lake County, Tennessee.
Asshole.
And they're going through various motions. The Lake County Judge Mark Hayes going through various motions. You
Shut
can watch
up.
this live on our streaming channel
We
and
are.
also on Facebook. We're going to have the latest on Action News 5 midday coming up at the top of the hour. For now, Andrew Douglas signing off on Action News 5's digital desk.
Confident that they've exhausted the motion, the pretrial motions that need to be filed.
Yes, that was better.
Right, I agree. I just wanted to address it, and I would like an order, down on it so that it's clear.
He's just going to start talking, doing his work.
Taking it up.
Oh my God. This might be just as
Defendants filed a motion to suppress statements, and I understand that that's probably just a preliminary filing to protect the issue.
Yes, sir.
At this time, are there any statements of the defendant that
he's going to let one rip. Oh, Lord.
need to be heard and considered by
Oh,
the
we
court?
can still
under
hear the
this-
judge.
Under this motion.
Jenny,
Oh, God.
before you go on,
Not at this time, Judge.
Thursday,
I will discuss that.
am I doing something with the breast cancer or something or other? It's the 21st.
Oh, my God.
Yeah.
I understand.
I haven't received any. No.
Just
So if
Oh
you
my
could just,
God.
yeah, just send me something.
You know, that's
Thank you.
what's the best way to leave that? Deferred,
All right.
Well, no, I mean, the only issue is just not.
deferring the motion to suppress statements. Defendants filed a motion to reveal any agreements with state witnesses. The state does not oppose it. And my notes indicate that there are no agreements that have been revealed or to be revealed. I assume the state, if they don't oppose the motion, would
Wow,
reveal
people.
any agreements made with state witnesses. So let's have an order, Mr. Huffman, showing that motion is granted.
Sorry, guys. I was almost ready to just
The
leave that
defendants
on.
filed a motion for a change of venue. In this case, the state does not oppose. the
Nice.
motion. Board intends to grant the motion.
Very good.
No alternate venue has been selected. I'm open to suggestions about that, with the underlying why this would be the place to do it. I think that for this particular case, Dyer County, as the other county in this district, is probably not the appropriate place to try to conduct the trial. So I think we've got to go.
All right, I'll pause it because I see some people saying what's going on. So they also filed a motion for change of venue because this is a very small town. Everybody knows each other, literally. So the judge has agreed to move it. And they're just talking now about where they would move it to within the state of Tennessee. So let's see if I can rewind a second here.
Conduct the trial, so I think we've got to go a little bit farther out there. As you know, we're commencing trial. Mr. Drummond has another case that's going to be tried July 23 and 24 in Carroll County. We'll find out pretty quick there whether and what. And that may prevent us from being there for this particular matter.
Does the court wish to be heard on your mail?
I'll have to see it on the news, you know.
Absolutely.
Where
I will send
where
you,
you want to
I
go.
will send you a memorandum.
That, you know,
I think the state has a suggestion already.
has a suggestion.
All right, I'm going to pause it there. The state's about to give a suggestion. So Carroll County is the other county where he has pending cases. So what happened was while he was in jail, since he was, I think, 17. I got to go back and look through my notes, but I think the offense happened when he was 17. It was like a, a robbery at a convenience store. I think he took like a couple of cents, a couple of dollars. Um, and while he was in there, he picked up some charges. He picked up an attempted murder charge for getting into a fight. And on one of our other streams, we played that video from the prison. And I think a possession charge. I'll look into it, and when we're finished with this, I'll I'll provide you more because my memory is for shit. But those cases, or at least one of those cases, I think I'm fairly certain, 99. Yes, I am certain. The attempted murder charge up in Carroll County in July, which the judge just spoke about. So he was saying, well, we can see if Carroll County will work because we're going to be out there. We're going to be able to pick a jury. But then he followed that up by saying, well, but maybe just the mere fact that we have that trial there might get everybody in that county paying attention to it, the other case. And that might, take that county out of the possible places where they can do this. So now that's the other thing. Nosy. Thank you. Um, so he got released from prison with none of these charges. Nothing happened for like a year on one of them. No actual charges were ever actually filed, but that's when the events occurred, like a long time ago. But they never, and one of them they charged or but never took to court ever because he was working as a confidential informant. And because of that, they weren't taking any action on those cases, which they had agreed not to do. Then this case happened, and all of a sudden they started to take those other cases to court as well. So although they happened while he was in prison, he was released, he was out of prison, he was continuing to work as a confidential informant out of prison, and then this case happened with the alleged murder, or self-defense, as he says, of the four family members. So let's hear what I don't know what's taking Bob so long to get on with us.
Yeah, I'm here. Yeah.
He wants to hear it.
Drummond doesn't want to hear it.
The state feels that Dixon County would be an appropriate place to have this. The reason we say that is
Dixon.
towards Middle Tennessee. Hopefully, there's been media coverage here, but hopefully not as much. Plus, there's my understanding they also have a courtroom that's always available there. They have an extra courtroom. So as far as scheduling is concerned, it would be easier for us to schedule. That's the reason that we would suggest that.
Judge,
My concern is the Memphis media market, the Jackson media market.
and that's what I was gonna say, Judge, yes, the county courthouse, I've been in there multiple times, driving, during trials, not even close to.
Where's that?
It's gonna be.
Where are you talking?
The Gibson County,
Oh, Gibson.
Dixon County.
I think you said Gibson.
Okay, Dixon.
Oh, okay, that changes things, Judge.
Thank you.
I like that. Gibson County doesn't work. But we would suggest, probably something closer to East Tennessee, anything that gets us out of the Shelby County, Jackson area with the extensive media coverage, and looking at the population, to pull the death qualified veneer from, you're gonna need a significant population to get and so the four primary counties that I was looking at were Knox, Hamilton, Shelby, and Davidson, with the understanding that Shelby County, it is the largest county in Tennessee, so we've got a significant veneer to select from. But the concern with that one would be the media coverage on that. So the top four that we would be suggesting would be Knox, Hamilton, Shelby, and Davidson.
Have you considered
That would also
Martinsburg.
be within that realm.
Sir, it's within what I considered and thought about.
Yes.
It's not much I considered it yet because I don't know,
Right.
but I have thought about.
And state's not opposed to any of those with the exception of Shelby County. We do object to Shelby County just because of the media. There's been so much coverage on this that we're concerned about the potential jury.
And I can understand.
Your first and sure would make travel easier for you, wouldn't it?
Well, yes, sure would. I've tried a lot of cases, obviously, most of the cases are in Shelby County, and they're usually 2 or 3 years, 2 years after the attacks. Like the guy who ran around all over Memphis killing and shooting people all day, or closed the city down. By the time it came around to pick a jury, nobody remembered it. Memphis has a really short memory of crime because we have so much. I hate to say that in a file, but we would still be able to effectively pick a jury from there if we had to. It would just be an issue of particular concern of two folks. But
Would there be a courtroom available?
oh yes, we're going to get 2 new judges. I'm sure that there are plenty of judges there who'd love to take a holiday and let you have the courtroom. There's also courtrooms in other buildings down there used for certain court buildings, which would be set up to have a jury trial across the street. But we would not have any trouble getting somebody down there to let us use the courthouse.
And the jury veneer is almost always,
It's also
a jury veneer there is almost always available.
it's always available, and because of our jury commissioner, they're very good about, they bring in 300 every Monday. What they do, or what we do, is we actually go and get our own separate veneer, bring them in a week or 2 early. If we're doing jury, if we're doing questionnaires, bring them in about a month early, and then those people would be sequestered off of the normal 300 at each $2. So we wouldn't be competing with any of the trials.
Okay. All right, thank you for the information, I appreciate it. You finished with that, Mr. Drummond? Do you have any questions about it? Would you all pass that back up to? Thank you. There's been a request for speedy trial filed on behalf of the defendant as well. The court will set the matter for trial at the first available opportunity to do so. Cases of this kind they move at a slower pace than anybody thinks they're going to. They demand an inordinate amount of time in order to get ready for the actual trial, and given the fact that we're going to be moving to a different county, is going to be subject to scheduling and whatever venue we wind up. But it's the court's intention to set this matter at the first available opportunity we can, and the court is going to be very aggressive about enforcing deadlines that are imposed so that we can get this case tried. The interest of the defendant, the public, the victims in this matter, their families are to reach a conclusion at the first opportunity we can. That's what I intend to do. Sir?
I have a question concerning protective order.
Well, we're not there yet.
He said he has a question about the protective order. All right. We got a special guest. I don't know why he's hiding back there.
There was a motion.
I was waiting.
Hey,
Don't you like to be on top?
it worked.
Oh, yeah. Oh, wait, you like to be on the bottom?
That's very personal,
know.
babe.
Pull your mind out of the gutter.
Oh, sorry. I'll rewind that, people. Just ignore that. You know,
Oh, yeah.
sometimes married people talk like that. Don't worry about it. Nothing here. Were you watching back screen or off stage or whatever?
Yeah, I was in chat. I was in chat.
So you heard the guy start just
Oh,
talking.
yeah. Saw the whole kerfuffle. It was quite a thing. It's like,
All right.
I was wondering why one of the producers, like in the booth, isn't like, hey, dude, your mic's hot. Shut the fuck up.
I was waiting for him to rip one, like as soon as he got off, like,
Oh,
I've been
yeah.
waiting. Been waiting for
Oh,
that one.
that one's been percolating.
So disgusting this morning. Sorry, everybody.
Oh boy.
All right, let's go. And I'm going to give a detailed breakdown when we're done with this.
Hello, beautiful humans.
There was a motion filed to enforce
You're not the only one that said that
statutory
this
review
morning.
requirements and to remand the
Hold on.
defendant to the custody of the local jail. Let's go ahead and check that matter right now. There, Mr. Huffman, I think it's your motion, so.
Yes, right. So back before Mr. Drummond was sent to PDOC, the court had a hearing on the requirements on what, if the local jail is insufficient to pay Mr. Drummond. The court made an order, and that's why he's in it right now. However, the statute requires the court to review that every 30 days to determine if that it's still the same thing. Any local county jail is insufficient.
All right, people. So let's give you a little update of what's happening now. So Austin Drummond, not unlike Richard Allen, has been moved to a prison. And he's got all the same similar issues. Now, it's actually my understanding that he doesn't mind where he is. I don't think. I could be wrong. Um, but his lawyer is saying here that the judge has to review that every 30 days. Now they filed an appeal. It went up to the higher court. I can't remember if I'm pretty sure it was the appellate court. Yeah, not the Supreme Court. And they upheld it and said, nope, he's a danger. And this talk about him, because of some of his informing involved informing on correction officers in the Tennessee Department of Corrections. So, you know, and Cody says he is in Gen Pop, and that's what I thought. He's just still having issues with, being able to communicate with his lawyers, meet with his lawyers. And as Lady points out, prisons usually have better law libraries. Hold on a sec, sorry.
Yeah, they definitely have better law libraries.
Which I do know was something important to him. So I don't know if that's one of the reasons why he likes that, but I also think he said he needed a better law library. So I don't know if where he's at has a good one or if that was while he was still in jail. I can't recall on that.
So,
on that
babe,
issue.
I missed the beginning portion, which I'm assuming is when the judge addressed him representing himself.
So he did, and he gave he gave him a sheet of paper of his rights and things to answer in that regard. And then I got to clear my throat. Let me clear my throat.
What's going on?
I don't know. My allergies were really bad yesterday. I almost didn't want to come on the live, people, because I get all puffy and yucky. So maybe it's just still that. So in any event, the judge was like, all right, I'm going to have you look this over and we're going to keep talking about the other motions. And then I kind of paid a little bit of attention to Jerry graduating, but I don't think I missed him come back to that. So unless you guys out there saw something different, I think it's still something he's waiting to.
So he didn't fully admonish him.
No, he did not. But he gave him the paper. They started to talk about it. So
he's taking under advisement, basically.
I don't know if he's literally might be coming back to it at the end of this hearing. He's taking
that can't be it. Like, this is a death penalty case. Like, that can't be all the judge is going to do in terms of admonishing him.
No, I don't think so.
Yeah,
oh wait,
so bad idea.
Let's
it's
see.
A really bad idea.
It says he said he won't address the motion today. No, I think that was a different motion. He had other motions that he filed. Let me just double check the date of that of that motion. It was definitely before May 1st that he filed a handwritten motion. I know that to be true because we went live. Otherwise, we would have been in New Orleans for Jazz Fest. So that motion was timely filed. It was some other of his other motions. And yes, as Greek Lady points out, as of now, the judge has said, you're still represented today. I'm talking to your lawyers, not you. But he did allow him to speak on another issue. So I think he's coming back to it either way to say, I'm not deciding today or what the next
I
steps
mean,
are.
if we're to look forward into a world in which Austin Drummond is representing himself,
No good.
there's no way that he can deny him from being able to watch video stuff. Any of his discovery, he has
Right.
to be able to
Have all of it.
access his discovery.
Yeah.
There's no ifs, ands, or buts about it.
Yeah, and the other thing while we're paused, when they talked about discovery and the lawyer stood up and says, "No, I think they've given me everything that they have." That's not Austin's understanding, and I think his investigator might be waiting for some text messages and things like that, but Austin filed a motion for discovery, and I think he's claiming his lawyers had said that they don't have things, or maybe it was the investigator, because I think he's been in communication more with the investigator than with his own lawyers, but he still felt things were outstanding. And then his defense counsel stood up and said, no, we have everything they have. And the state said, well, we still have some reports, some lab reports that are outstanding and other things like that. But I didn't hear any mention of text messages.
Huh.
Heads
All right.
and debutantes. Crackheads and debutantes.
All right, so that was for Trial World. Tell me more. Tell me more. You have me peaked there.
Wait,
Trial
what's
World says that one of the
well,
I'm
put
assuming
it up.
voice actors that did.
Put it
I
up.
had it up. I had it up.
Oh, well, then I didn't see it.
You aced it. It
Sorry.
was that one of the actors, and I'm assuming voice actors for King of the Hill, was murdered.
No.
Oh yeah, there, right
Ew.
here. This is the one. King of the
Oh.
Hill actor that was murdered might be an interesting case to follow. So that's why I played the Hank Hill voice clip.
That's awful. I thought somebody did like one person did most of the voices.
No,
No?
I mean Mike Judge did a lot of them.
Right. There was
Like
someone who
Mike
did
Judge
multiple.
did Hank Hill,
They
Mr.
said it's
Thompson or Mr. Anderson back in the
Jonathan
Beavis and
Josh.
Butthead days. Yeah, it's crazy. I'll have to look it up.
All right, yeah, we'll look into it.
Jonathan Joss. Is that Boomhauer?
Dang it, Bobby.
All right. Okay.
You're still
Sorry,
playing.
I'm done. I'm done.
Okay. All right, let's get back to Mr. Drummond here.
To house Mr. Drummond pending trial. He's obviously a pre-trial detainee. It should be normal course of business would be to have him housed in the local county jail. And of course,
Right, but that ship has sailed.
That ship has sailed.
I'm happy to do the statutory required review.
well, the court is required to look at that to determine if there is still insufficient local jails. And the court only heard, of course, it's not my case, it was in the other Mr. Farmer's case. The court only heard from Bryan and Lake County and I think Dyer County. But there is a whole bunch of other local jails in West Tennessee that would be more than sufficient. And the court needs to hear what the state has done to look at to finding a sufficient jail, not an inconvenient jail. It might be inconvenient for a jail to house them, but of course, you can take judicial notice that they house dangerous criminals all the
My
time.
husband's face.
Contraband gets in all the
Not.
time. The court needs to look at whether or not there is a sufficient jail in anywhere in West Tennessee, not just TDOC, and not just Lake, not just Dyer. You know, you got going down 51, you got Lauderdale, Tipton, Shelby County, 201, obviously houses very dangerous criminals, and they wouldn't be sufficient. But there's a whole bunch of jails that are available that were not considered at that hearing.
Does the defendant have information, specific information that would help the court make findings?
I'm not sure what the court is looking for. I mean,
It's your motion.
I understand, Judge, but the court is required to hear from the local jails. What efforts did the government make to find a sufficient jail? I mean, just because he's in TOC now does not mean that he is not required, cannot be remanded to a sufficient jail. And again, you know, inconvenience for the jail is not something that is standard. The standard is whether or not it's insufficient.
Well, it sounds like under your theory of this thing, the court's required to have a completely new hearing every 30 days
That's correct.
to decide whether or not there is a local jail.
That's correct.
But you asked for that review under 41-4-121,
Yes,
right?
yes, sir.
Okay, so that statute says An order issued under this section shall be reviewed by the issuing court at least once every 30 days. In conducting the review, the court shall determine whether the order needs to remain in place, be terminated, or be modified to place conditions on the order. Now, here's the part I'm really interested in. In evaluating whether the order needs to remain in place, the court shall consider the jail or juvenile detention facility's obligations relative to the use of restrictive housing. That's what I'm required to review.
Yes, sir.
If the order is terminated, the prisoner shall be returned to the county jail. Juvenile detention facility doesn't apply because he's not a juvenile. Shall be returned to the county jail. So what do you think that tells me I've got to do? Do you think I need to take a survey of jails throughout West Tennessee to determine whether or not there's a jail that can house the defendant?
I mean, I'm not sure that would be a survey per se for the court to do.
No, I don't think it, you know, as you know, that's
Yes.
not my role.
Yes, but the state's motion, they presented testimony that, that he was getting disciplinary issues. But again, matter of convenience is not the standard. It's whether or not the jail is sufficient. And it's a continuing duty. Do the conditions still exist today in Lake County? Do the conditions still exist today in Bryan County, Dyer County, any of the local jails, especially within this district?
Well, to that end, do you have any information that the Lake County Jail or the Bryan County Jail are better suited to house Mr. Drummond than they were when the order was initially issued?
Well, I'll stipulate that Lake County would not be appropriate. It's small, and given the issues that have come up already, I don't think that Lake County would necessarily be.
Babe, it's time to wake up from your nap.
Sufficient. Bryan County testified that it was inconvenient.
So here's what I'm trying to do while I'm looking down. So I was posting a lot on X, like while I was researching this case and like looking through the docket and trying to get facts. So I'm like trying to get Grok to help me and I was like, wait a minute, I included more than just that. Come on. So that's why I was looking down. I was not napping.
Time to wake up, babe. It's time to get up.
Bye.
It would not be appropriate. It's small, and
Jerk off.
given the issues that have come up already, I don't think that Lake County would necessarily be someplace that would be sufficient, I guess is the word I'm looking for. Bryan County testified that it was inconvenient, and he was causing problems, but I don't know if those conditions still exist at Bryan County. The sheriff is here to testify, but as far as that's concerned.
They know what the state's.
The state's.
Okay.
Yes, sir.
Okay.
He is here. Dyer County's here as well. I'm not.
Well, you know, the court's order was reviewed by the Court of Criminal Appeals.
Say again, Judge?
The court's
yes,
order was
yes.
reviewed by the Court of Criminal Appeals.
Yes,
And it remains in force.
yes. And I'm not suggesting that it was necessarily wrong at that time. But under the statute, the court has to determine if those conditions still exist.
Thank you very much.
Your Honor, first of all, on the issue of the 30-day review, this is not the proper case to be reviewed at full. He was not
Shouldn't matter.
transferred to safekeeping and TLC for the case that we're here for today. He was transferred under docket numbers 23 CR 10945 and 24 CR 11036. And those are two separate cases that occurred while he was still incarcerated. So those are actually the cases that require the review, not the case today. In addition to that,
Thanks, Hope. My middle name.
concern with this is this motion is for him to be remanded to the local jail. The problem I see with that is the only jail that is required to hold him at the local jail is the Lake County Jail. I don't think the court has the authority or me or anyone else to order another jail that is outside of this county to hold an inmate. It's not their obligation, it's not their responsibility. So if the court granted this, I think the only one that the court would order to hold him would be the Lake County Jail. And it's obvious that jail is not sufficient the defense even agrees.
I'm confused. Why can he order a prison to hold them, but not a jail? Doesn't seem right, does it, babe? What's happening? Am I muted? Is
Oh,
he
sorry. I
muted?
was reading about that Jonathan Joss thing.
Oh,
No, I mean, it sounds like Richard Allen.
yeah. All right, let's see what the judge says back.
That jail is not sufficient.
Do they have him
Already
in Gen
heard
Pop?
from Oline County and our county
That's what
about their willingness.
That's what Cody from Tennessee said, and I think that's what I remember, but I'm not sure.
I mean, he saved the baby.
He did. He did. Except you hear Channel 5 News describe it. He abandoned a baby.
Wow.
Yeah.
Wow.
Yeah.
So
I
Tony
mean-
Bruschi and Robin Dreek, my homies over there on Tony's channel, they sounded in on Austin Drummond. I
Yeah.
texted them like, "Oh, we should chat about it." Yeah, because they're like, they've got Austin pegged as a nutball. Like Tony's like, "Oh, he's basically, Lori Vallow in terms of believing the shit that he's saying, except, different." But I think it's been substantiated that, like, what he was saying about being an informant, a
It
CI,
is
was all true.
absolutely positively. We did a live on it. We have the text messages between him and his handler. There's
Yeah.
no question, no doubt. The only question is, was this self-defense or wasn't it?
I really want to hear the theory about that. I'm dying to hear the theory. I mean,
know
you
the
have to
theory.
assume that if he, the theory?
Yeah, we can talk about it after this.
What? Well, that's no fun.
Well, I mean, you want me to talk about it straight in the middle? What do you guys want?
Oh, yeah,
What do
we'll
the
wait.
people want?
We'll wait.
Okay, we're
Maybe
waiting.
you should set a goal and then you'll tell people the theory. Is it public consumption? The
Yeah.
theory? Oh, it's
Yeah,
out there?
It's been out there.
Oh, well. Yeah, that's what I'm wondering. Like, I need to
Okay,
understand logistically how that went down.
All right, he is in segregation. I have confirmed that. He is in segregation.
Okay.
So
I'll take
right.
it you have it on good authority.
I have it on good authority.
Yeah.
All right.
Sufficient. The defense even agrees that jail is not sufficient. You've already heard from Oline County and our county about their willingness to hold them. I actually have them here again today. Their testimony would basically be the same.
Is that Jerry Holman?
So I'm happy to put them on. But I think
Sounds exactly like him.
All right. You're talking over the guy. This Jerry Holman look-alike.
Well, it's
You've already
Jerry
heard
Holman
the
sound alike.
And it's obvious.
Oh, Jerry Holman sound alike.
And from the
Okay.
back, he could be
Anybody.
confused for Jerry Holman.
That jail is not sufficient. The defense even agrees that jail is not sufficient. You've already heard from Oline County and our county about their willingness to hold them. I actually have them here again today. Their testimony would basically be the same as it was in the previous hearing. So I'm happy to put them on, but I think it would be repetitive as to what the court's already heard.
Ouch.
So I think that is the major
No.
issue. In addition to that, Mr. Drummond has continued, as I stated previously, to have issues even while he's in Department of Corrections for the safekeeping.
He's got a little bit more of a twang.
And we have certified documents that show the
Show what?
disciplinary issues that he's had since he's been in the Department of Corrections. So if there are issues there, who is the best person equipped to deal with him, there's obviously going to be more serious issues than what we do. So based on that, we think that it's appropriate and remain where it is.
Babe.
Motion should be denied.
Maybe we should go out to Brecky after this.
I used 41.4.
I need coffee, I'll tell you that.
I feel like I need to. In terms of being complete, A2, subsection A2, in all cases where it is shown to the committee in court, I guess that's our court,
Yes.
that the jail of the county in which the commitment should be made is insufficient for safekeeping of the prisoner, the court may order commitment of the prisoner to the nearest sufficient county jail. I think it is within the authority of the court to require.
Thank you,
county,
Judge.
as counterintuitive as that may seem, and that is what the legislature said about that.
All right, so the judge just confirmed the prosecution was wrong, and the instinct of Bob and I was correct, that the judge does in fact have authority to transfer him to the nearest sufficient jail.
Yeah,
So they got to
of
take
course.
everything into account. All right, let's go.
So I think I've got that, but that does not, that's a far cry from is this an appropriate case to do that? So I want to hear you prove today.
Cool.
The issue.
I like that.
Yes. Governor Karl
Been
shared.
been a stipulation that Lake County, right, is not sufficient to.
I'm about to call Sheriff Jeff Fox.
That'll definitely help because Bob's got me on scheduling duty, figuring out cases and finding guests. You know who I thought would be a great guest when I do these things?
Who?
You.
Oh yeah. Hi. Hi. We're live.
State your name, please. Jeff Fox. And, Sheriff Fox, which county are you sheriff for? And as a sheriff of our county, you also maintain a jail. Approximately how many inmates, how many?
That's so sweet.
We have 236 total, 2 buildings.
And, how many jailers do you have?
V-Dubs is the sweetest.
There's 23 on the payroll.
And do you have a pod of cells that are designed to hold, maximum security prisoners?
I do.
Do it.
And,
Do it.
are you familiar with the case involving Austin Drummond?
Yes, I am.
Has he been held in your jail previously?
I believe he may have been at one point. General, I'm not sure.
Do you feel that your jail is sufficient to house, Mr. Drummond?
General, we're at 103% capacity. We have 245 inmates today with a 236 capacity. You can't segregate properly once you get above 85% of your capacity because a lot of these cells and pods may have 10 to 12 people in them. They're all not maximum or segregation pods, and most of those are full.
I forget how old Gannicus is.
Other vendors, plus also I have one of the victims' stepbrothers.
I want to say 8 or 9.
And so would it be fair to say that person, Mr. Drummond, would not be compatible in that jail?
They wouldn't be compatible at all.
All right, so the sheriff is claiming because they house some of the family members of the victims that he definitely can't stay in their jail. That's what he's saying. No. We can't even. We've got all these jails, but we don't have different like units where they wouldn't come in contact with each other. I mean, you're telling me, all right, it's a small town. Everybody knows everybody. But they figured this out for every other person that's in jail. They also said, people have a short memory here because we have so much crime. That's the other argument the state made. So I don't know. Talk about arguing just right outside both sides of your ass.
Hey, Granny
babe?
Debbie. Yes,
Both sides of your ass.
I'm having like flashbacks to the safekeeping hearings for Richard Allen.
Yeah.
Like
Yeah.
this is exactly what they did. They put on the warden of Westville, and they brought in the county sheriff who was running the county jail where they were trying to put Rick, where he ended up for trial, Cass County. And, it was same shit, but Cass County was worse because Cass County said we can accommodate him. We don't want him, but we can accommodate him, I mean, and those are two different things, obviously. So,
Yep.
yeah.
All
I
right,
mean,
let's-
maybe let some of the, the drug cases go. Let them go out on bond. Like,
Right.
seriously.
I mean, yeah.
Patients.
'Cause I'm sure most of them are drug cases, meth bullshit, weed, whatever.
Right.
they're all not maximum or segregation pods. And most of those are full with mental health patients and other violent offenders. Plus also I have one of the victim's stepbrothers incarcerated this time there too.
And so would it be fair to say that person, Mr. Drummond, would not be compatible in that jail?
They wouldn't be compatible at all.
So based on that information, do you think that you have the appropriate facilities to be able to house Mr. Drummond?
No, sir, I don't.
Oh,
I'm under a
oral
plan of
argument.
action to go
Yeah,
crowded
pause
at this
it.
time in the state of Tennessee.
Oops,
And we're
hold on,
building
I'm
additional
sorry.
Sales at this time, so it would not.
What?
I was, Aaron had asked, and then Michelle had asked if we were covering oral arguments for Alan. Yes, of course we are.
Of course
So,
we are. We're
the
talking
way-
about Austin Drummond, though.
I know, but people had
All
asked
right,
in
go ahead.
chat. Wow.
Go ahead.
Gee whiz. Jeepers. Yeah. So I'm going to try to get in. You know, there's obviously going to be limited seating when the lawyers were getting back on the case, and I went for that. I got lucky and I got a ticket. I don't know if they're going to do the ticket thing. I mean, maybe a bunch of people won't come.
I
don't-
think it'll be less people since they're gonna have it, live
Streamed.
streamed.
Yeah. I mean, that's the hope. But yeah, so Al, if I end up getting in, Allie will obviously be streaming it live. And then I'll come on the live when I'm out, for in court type, behind the scenes shit that you couldn't see from the live stream, because they basically have one camera in there, maybe two.
Yeah.
So
You got
yeah.
old eyes like me, definitely can't see the judges.
I can't see.
Faces.
What are they doing? I'll tell you, I looked up the three judges on the panel. Not thrilled. 2 former prosecutor track judges and another one. I asked Osbrook and Kara, I'm like, what do you guys think of this panel? You get who you get.
Yeah.
You get who you get. I mean, my gut feeling is that this thing's going to they're going to uphold it, and then it's going to go to the Indiana Supreme Court. I think that's where the hay is going to be made. So it's going to be a process. I hope I'm wrong, though. I really, really hope I'm wrong. Oh, Allie's napping again.
No, I'm trying to get approval to play. I'm trying to get approval to play his recorded statement because it's on another channel.
What the one?
Just leave it.
What?
All
Wow.
right.
Kara's always more optimistic, which I love about her.
Yes.
She's
All right,
eternally
let's go.
optimistic.
Mr. Drummond would not be compatible in that jail.
They wouldn't be compatible at all.
So based on that information, do you think that you have the appropriate facilities to be able to house Mr. Drummond?
No, sir, I don't. I'm under a plan of action to go crowded at this time in the state of Tennessee. And we're building additional cells at this time, so it would not be fruitful at all for me to take a prisoner on the secondary charge or the primary charges.
Of course not.
No questions.
Shake down. Thank you, Sheriff.
Thank you.
Wait,
Before you go.
defense had no questions?
No.
Call Sheriff Jackson.
Weird.
I thought we had a live where we played the recorded statements. Didn't we, babe? It's got me on the
Not,
peanut line
not
list.
this one.
Oh yeah, different one.
State your name, please.
Carl Jackson,
And Sheriff Jackson, which county are you sheriff for?
O'Brien County.
And in O'Brien County, how many beds do you have at your facility?
We have 159 beds.
How many people do you currently house there?
I think our ADP today is 132, I believe. I'm sorry, 137.
37. And I think you previously housed Mr. Drummond, is that correct?
Yes, sir, we did.
And do you have a facility that can hold max prisoners?
Yes, sir, we did.
And when you held Mr. Drummond, were there issues?
Yes, sir, there were.
What type of issues did you have?
Mainly manipulation issues. We had a drug issue one time.
It was, in my opinion, very taxing on our staff to have to deal with him when we brought him out. For wreck, we were having to take safety precautions during that wreck. I mean, if he doesn't get his way, he acts out, maybe not violently, but in other ways, such as smearing feces on the walls. And on the window for the cell door. He also would write little notes about when this happens, you're responsible, basically.
Were those, did you take those as threats?
I took it as him trying to manipulate the staff and basically do what he could to have his way.
Do you feel that your jail is sufficient to hold Mr. Drummond? You've already held him, so you have a better idea probably than others.
We currently, and I'll just be frank, right now, we're currently holding 3 inmates in our jail for murder. One is a 15-year-old or 16-year-old juvenile. Another one's one that shot a Weakley County deputy. We're holding that one for Weakley County. And we have one that we're actually holding for Sheriff Box right now as well. So I feel that we're doing our part for this area.
And do those people take additional staff when you have people that require more security?
They do.
And you're providing extra security now for those 3 that you're holding?
And we have to take a lot of extra precautions for the juvenile. Yes, sir. That's very taxing as well.
Will this be a burden?
Yes, sir. It would be a burden on Bryan County Jail, our staff, and quite frankly, the citizens of Bryan County. I mean, I've got 6 other officers here today other than me.
Sheriff Jackson, you just testified that you deal with violent criminals.
Yes, sir.
Like you got 3 that are pretty high priority.
Yes, sir.
Did those criminals act out? They're not model citizens.
As far as right now, no, everybody is under control right now. We just.
So sorry, I'll bleep it back, everybody, but it's not a recorded statement he made to law enforcement. It's a recorded statement he made to a creator, I think over the phone while he was in jail. So I don't know, he might be able to get it from a FOIA for the jail recording, because I guess it would have had to been while he was in jail, and it would have had to been recorded. I'm actually going to see if maybe we can get her to come on with us, and then that way we can use the raw data instead of listening to her talk about the raw data. So we'll look into that, but we'll give you some details when we're off. Explain to Trial World TV why it's not, ridiculous, but let's keep going.
Sheriff Jackson, you just
Thanks,
testified
Trial World.
that you deal with violent criminals.
Yes, sir.
Like you got 3 that are pretty high priority.
Yes, sir.
Did those criminals act out? They're not model citizens.
As far as right now, no, everybody is under control right now. We just took the juvenile a few days ago, so that's still in the process.
Would it be fair to say that you routinely deal with difficult prisoners?
Occasionally, yes.
And your staff's able to handle those?
Most of the time. Sometimes we have to call road deputies in to assist. This would just be an extra burden on us at this time.
And so previously you just now testified that he manipulated the staff and had drug issues.
He attempted to manipulate, yes, sir.
He was violent with staff.
No, sir.
Did he ever try to escape?
No, sir, but he did give a plan of escape to a confidential source within the facility.
He was being segregated from all inmates, correct?
Yes, with the exception of the maximum security pod, and we did try to keep that separation, but even at that, when he used a phone, he was using somebody else's PIN number to make phone calls to get out. He continued to try to manipulate the situation.
So manipulative.
That's not unusual for inmates.
I don't believe we've ever had this much trouble since I've been sheriff.
You have gang members in Bryan County?
We do. We have to separate them.
Do they ever pass notes and things of that nature?
Everybody's always moving kites, just
Moving
That's
what?
not unusual for Mr. Drummond to do those types of things.
some of it. I mean, I don't have people that's leaving notes around trying to manipulate staff, trying to talk about what he did before he came to jail.
So no other gang members do those types of things?
I don't have anybody trying to manipulate the staff that I know of.
Are your staff easily swayed?
Well,
You got a bunch-
currently we're going through a rehire process where we
Wow, your staff is easily manipulated and swayed by the inmates. All right, people, as you can see, I was looking down for some of that. Has he specified specifically what is in the notes and how he manipulated them, or he's just saying he was trying to manipulate people?
He just basically said that he was trying to manipulate people, you know, that he would smear feces on the wall and that he would, you know, he was basically kind of threatening, saying whatever happens to me is on you. So like, I don't know if that's what he's saying in terms of trying to manipulate them. But look, I mean, the reality for Austin Drummond is he's been incarcerated since the kid was like 19. Like he is like a true inmate. He has been 100% institutionalized. I mean, that's really all, like, you know, you want to talk about Red from Shawshank, talking about people being institutionalized. This guy has been in forever. Like he's probably more accustomed to being in than he is to being out. So in terms of kind of learning how to operate within the confines of a correctional facility, I mean, that's a skill set that you learn when you're in there. I mean, in terms of survival, in terms of being able to get things that you can't normally get, maybe from the outside, somehow getting in, any kind of
I'm sure
contraband.
he definitely knew how they were doing all of that. It's part of what he was informing on.
Yeah.
All the corrections officers bringing in, contraband and getting drugs in and dealing drugs and all the things and all the such.
I heard he
So,
made some of the best Pruno out there too.
what's
know.
Pruno?
Come on, man. It's jail wine. It's the toilet wine they make.
Oh,
Oh, yeah.
Bob's just joking. He doesn't know
Oh,
that.
yeah.
It's just being funny.
Oh, yeah. Pruno. Delicious.
Bites my bits says he ran a store in prison. He's a hustler. I mean, like Bob said, he wasn't even supposed to be in there for 11 years. He had been cooperating. That was supposed to get him out. Like they just kept him in there forever. Unlike, I swear it was like $4 or something. Grok is saying I didn't post a tweet about that, and I'm shocked that it must be in one of our lives then. But yeah, one must have to have a hustle. Gotta have your hustle.
Side hustle. I mean, that's
Yeah.
how you
Front
survive in the
hustle.
joint. That's how you survive. I mean,
All
look
right.
at Red.
Yeah.
Red,
I mean,
I heard you're a man who can get things.
he could get things, and he was such a wonderful prisoner. Otherwise,
Only guilty man in Shawshank.
overall great guilty man, though.
Oh, yeah. Oh, yeah.
All right, let's keep going.
I mean, I don't have people that's leaving notes around trying to manipulate staff, trying to talk about what he did before he came to jail.
Only guilty
So
man in
no other
Shawshank.
gang members do those types of things?
I don't have anybody trying to manipulate the staff that I know of.
Are your staff easily swayed?
Well, currently we're going through a rehire process where we've hired 6 new staff that are currently in training. So, anytime you have somebody new, they have to learn the ropes and they could be easily manipulated.
Wow.
You have a system set up to screen those types of things, correct?
We try our best. But
Wow.
just like any place, people get through.
This guy.
I understand. Inmates can be pretty creative. Would you think?
Yes, sir, they have 24/7 to figure something out.
Do any other inmates act out when they don't get their way?
Occasionally, we have had some.
Mr. Drummond was not an unusual case, other than the fact of what he's charged with, and no writing.
Other than the manipulative notes and actions.
Bunch of manipulative notes.
In addition to holding state inmates, county inmates, do you also hold federal inmates?
Yes, sir, we do.
And does that require you to have additional staff for that as well?
We have to segregate them separately, which also takes up room. I guess best way to describe it, if you have B-Pod, which has 22 inmates in it. That's 22 federal inmates. So we have B-Pod, we have E-Pod and F-Pod that are all federal inmates. That limits where we can stick somebody. So if we wind up having trouble and we have to utilize D-Max and we don't have anybody to put them or anywhere to put them, then that makes it even more difficult for us.
So does that also make it, to a point or so that your jail is not sufficient to house drugs?
At this point in time, I feel like we're more taxed than we were when he left.
Sheriff, are you required to take federal inmates?
We have a contract, or whether it's an IGA, intergovernmental agreement with U.S. Marshals. And quite frankly, without the U.S. inmates, we would be in a heck of a financial jam.
So you get paid to take the federal inmates? Right?
Yes, sir, they actually help us pay our bills.
And you also take money from state inmates as well?
Yes, sir, nowhere near the coverage of. Thank you, Your Honor.
Your Honor, no other proof, however, the documents that I passed forward, I would like those to be
Objection, certified copy, just get a mark.
Let's say.
No proof of this, Judge.
None. How do you propose this review works going forward? When you file a motion to conduct 30-day review.
Judge,
I'm not able to convene and subpoena, have witnesses brought in every 30 days.
I understand, Judge, and I do also understand that, yes, that he's being housed with the UNC on this other case, which is sort of, it's collateral attack, if you will, because he's not being housed to UNC on this case.
Right.
But as a consequence of those cases, he's still being housed. And again, it's a pretrial detainee, and the court's required to conduct those reviews. In those cases, this is essentially bypassing those children and getting back to the court. Of course, he's got the jury trial coming up soon.
Right.
And that, if he is convicted in that case, it may render this issue moot.
Yeah, we're really talking about a 60-day window of time, or
Yes,
67 days to a trial.
yes. But the court still has the special allegation review every 30 days.
Thank you. I appreciate that. Anything else?
Yeah, as far as the review goes, I don't think the statute says that we have to actually come into court and have a hearing. It says the court has to review it. I don't know why that can't be done in chambers. And I think unless there is some new evidence, there's not much to review. I think that would be on the defense for them to bring in proof that, hey, we have found a jail that we think is sufficient. We're asking you to review and consider that.
Thank you. I was looking for the transfer order, and I hadn't been able to find it. Does anybody have a copy of that order? Original.
So is he making a transfer, or he's just going to read from his old order to find the same things? We shall see. I mean, the cameraman's getting a little close to like violating attorney-client privilege right there, like looking in the lawyer's file. The fuck on. What's this? Action 5? 5 action? A little too much action. I'm gonna go in there and say, stay out of the lawyer's file. I can't get into the comments while it's like this. Lucky. They're gonna be.
What I do know is originally, according to the state hearing on the request to transfer was conducted October 27th, of 2025, I expect. Which predates the indictment in this case, by the way. So I expect that order has been in effect since at least early November there.
Yeah, no lawyer's been asking you to review it every 30 days like you're supposed to.
The threshold question is whether the order should remain in place, be terminated or modified there. So the transfer had been in place since, or I think early November is a safe time. Question is, has the situation improved according to the testimony? According to the stipulation regarding the Lake County Jail, it is inadequate to hold the defendant pending trial. Excuse me.
I feel you, Judge.
Sheriff Box is over capacity in Dare County at this time. Also houses a relative of the victims. One of the victims in this case, Sheriff Jackson. The court found the conditions that existed in Bryan County created a situation where it was inadequate. There's been no proof that those conditions have improved. In fact, Sheriff Jackson has indicated, if anything, things are worse at that time. I don't think the court has any authority to require Bryan County to discharge or remand federal prisoners.
Hey, Bob says discharge some of your drug people.
In this case, that it's sheriff's duty and job to run the jail, not the court's job to run the jail there. Continued transfer then appears to remain necessary because there's no improvement in any close local jail.
I should have put a banner up. In case anyone doesn't know what's going on.
There's been no assertion by the defendant that the Department of Correction facility
Talking to me?
currently
Me,
housed
myself.
is insufficient, except to the extent it creates a barrier for the meaningful review and preparation, review of discovery and preparation for trial, where the court is working on that issue based on the prior hearing on the motion to modify the protective order. So it is not necessarily the Department of Correction that does not create a insufficiency. It just creates a barrier to preparation there. The conditions under which the defendant was originally transferred were related to safety and were not considered and were not intended to be punitive. There's no indication as to whether the defendant is in restrictive housing, as that term is used in 41.4.121 there. There's also no indication about whether the defendant is in solitary confinement.
Well,
That's an old term there, but there's no assertion.
pipe up, counsel. Wait.
The court will conduct a regular review.
Wait, let's see if that was him, if that was Austin speaking.
That's an old term there, but there's no assertion here. The court will conduct a regular.
So Austin tried to say something there. I don't know if that was him saying, I am in segregation. I am in solitary. I don't know. One second.
What are you doing?
Sorry.
Sounds like you're messaging. All right, that gives me a great opportunity. Everybody go and watch yesterday's Lucy Studi, Don Studi live. There was a little kerfuckle in the middle with the video that I made as it froze. But other than that, It's really, really good. And hype it. Please use your hype points on that video. It's like an insane story. Everyone should want to listen to that story. It's like shit you haven't heard. It's different. And it's crazy. It's a crazy story.
All right, let's keep going.
Review on some level in compliance with the statute there. And it doesn't seem at this time that the transfer of the Department of Correction amounted to an atypical or significant hardship, except with respect to the ability that we've talked about on review. The order granting the motion to transfer this was entered October 29, 2025. That order was subjected to review by the Court of Criminal Appeals. There are no less restrictive alternatives at this time. The access to counsel is a significant issue for the court, and the court's going to make that.
Thankfully.
We'll follow up with that with respect to the motion to modify the protective order. If we're able to find a way to deal with that on an electronic basis, I think that issue will be solved, and we'll have that be that's the only factor that really concerns the court. So at this time, the review has been completed, and the court declines to transfer the defendant back to a local jail at this point.
His lawyer's not going to pipe in about.
Other motions.
There's probably one other motion for mental evaluation, which the state did not oppose, and we've actually already entered an order.
Right.
We need to discuss it briefly. Dr. Styles, I think, from Pathways, went up to the Department of Corrections, stated Mr. Drummond, and he refused to file with the court order. This claim that not being recorded. As for that, it goes to litigation. It's the sentencing phase. But the email that Mr. Huffman and I got back from Pathways that Mr. Drummond refused to.
I knew I had not seen any result of that.
I might have misspoke a little bit. TDOC also would not let it be recorded without a court order. Maybe more TDOC would not record other than Pathways, but again, the refusal from Mr. Drummond staff.
All right, just a matter of information, I suppose. All right, Mr. Drummond, let's talk about your request to represent yourself, okay? Mr. Drummond filed a motion. It was received by the court and filed April 21, 2026, seeking to terminate counsel and to represent himself in the matter. The court's asked Mr. Drummond to complete the waiver questionnaire, which it appears he has done. There, he's also executed a written waiver of counsel in the matter. Mr. Drummond, I need to ask you some questions, sir. And I'm going to place you under oath to do that because I need you obligated to tell me the truth. So, you raise your right hand.
You solemnly swear that the testimony you're about to give is the truth, so help you God.
I do. Mr. Drummond, the court is required to advise you on the disadvantages and the dangers of self-representation, particularly in a case like this. And I'm going to also ask you some questions to determine whether your decision to represent yourself is being made knowingly and intelligently. You're obligated to answer course, truthfully, if you were to answer any question falsely, you could be punished for perjury. You know what perjury is, sir?
Yes, Your Honor.
You've handed back the document called waiver of right to be represented by counsel. Did you complete yourself the questions there?
Yes, Your Honor.
Some of the questions I'm going to ask you are going to duplicate what's in the form, but I think I want to hear you. Yeah. How old are you, sir?
29.
29?
Yes, sir.
You have a general equivalency diploma?
Yes. Yes, Your Honor.
What grade, what was the highest grade you completed in school, either public or private, before your GED?
10th grade.
10th?
Yes, sir.
Were you able to read through the waiver documents, 8 pages? Were you able to read that and comprehend that without any problem?
Yes, Your Honor.
Did you have to ask anybody what any of the words meant?
Not with the words, but no.
Okay.
Huh? Here we go.
Dumb question. Now, you've not been to law school.
No, Your Honor.
Have you ever undertaken any formal study of the law?
No, Your Honor.
Have you ever represented yourself in any case?
No, Your Honor.
I assume you didn't represent anybody else. Even in the Department of Correction, you didn't help someone else with their case, like a disciplinary hearing or anything.
No, Your Honor.
Have you ever been through or sat through the trial of a capital murder case?
Not a capital murder case.
What trials have you sat through?
My trial for the robbery when I was 16.
As a 16-year-old, you sat through a robbery trial, your own robbery
I
trial?
was 17 at the time. of trial.
17 at the trial? Madison County?
Yes, Your Honor.
You understand that you're charged with the first degree premeditated murder of Matthew Wilson in count 1 of the indictment, of Courtney Rose in count 2, of Adriana Williams in count 3, and of a juvenile BW in count 4 of this indictment, sir?
Yes, Your Honor.
You understand if you're found guilty of premeditated first degree murder, the jury could sentence you to life imprisonment without the possibility of ever being released or death. Understand that?
Yes, Your Honor.
Understand you're charged with the kidnapping of the juvenile BW in count 5 of the indictment, sir?
Yes, Your Honor.
And if you're found guilty of that, that's a Class A felony. You could be sentenced anywhere from 15 to 60 years at 100% service of that sentence.
Yes, Your Honor.
Understand in count 6 of the indictment, you're charged with being a convicted felon in possession of a firearm, sir.
Yes, Your Honor.
And that felony conviction relies on the conviction, the trial you referenced a few minutes ago, your aggravated robbery conviction in Madison County, case number 14 CR 423.
Yes, Your Honor.
That's a Class B felony, being a felon in possession of a firearm, and the sentence there could be 8 years to 30 years in prison as well. You understand that?
Yes, Your Honor.
Count 7, you're charged with employing a firearm during the commission of a dangerous felony. That's count 7. In count 8, employing a firearm in the first degree premeditated murder of Matthew Wilson. I'm sorry, that's count 7. In count 8, employing a dangerous firearm in the first degree premeditated murder of Courtney Rose. In count 9, employing a firearm in the first degree premeditated murder of Adriana Williams. And in count 10, employing a firearm.
Open your eyes whenever he says their name. Do you hear me? Open your fucking eyes. I'll leave. Open your fucking eyes, you bitch. I hate you, motherfucker. God damn you.
Whoa.
I'm gonna need the gentleman detained to take up that matter.
He's
gonna be Whoa.
detained. Should we watch it back?
Yeah.
In count 8,
I mean, his eyes are open.
premeditated murder of Matthew Wilson. I'm sorry, that's count 7. In count 8,
Just looking down.
employing a dangerous firearm in the first degree premeditated murder of Courtney Rose. In count 9, employing a firearm in the first degree premeditated murder of Adriana Williams. And in count 10,
Oh yeah, he closed them for a second.
Open your eyes whenever he says their name. Do you hear me? Open your fucking eyes. I'll leave.
Well, we don't know who he's
Fucking
talking
eyes,
to.
bitch.
He's
I
talking to
hate you,
him.
motherfucker.
Well, I know he's
talking to
talking to
Austin.
I know he's talking to him there.
I'm gonna need the gentleman detained.
What does he mean though?
He's gonna be detained.
He like had a long like he was.
No, that's he's not speaking literally to open your eyes. Like what is he like?
I think
what,
he was
I
saying
don't think
open your
so.
eyes when they read their names.
Oh, is that what he said?
Yeah, I'll play it back, but that's what he said.
Firearm in the first degree premeditated murder of Adriana Williams. And in count 10, employing a firearm.
Open your eyes whenever he says their name. Do you hear me? Open your fucking eyes. I'll leave. I'll leave. Open your fucking eyes, you
Yeah.
bitch.
He just
I
blinked.
hate you, motherfucker. God damn you.
It was a little bit of a
I'm
problem.
gonna need the gentleman detained. We'll take up that matter.
He's gonna be detained.
I
Oh, that's
mean,
Matthew Wilson's father.
And in count 10 of the indictment, employing a firearm during the first degree premeditated murder of Virginia. These are Class C felonies, Mr. Drummond. Those are each punishable. The range of punishment is 3 to 15 years. In prison, there's a mandatory minimum of 6 years there. You understand that, sir? Yes, sir. And in those counts of the indictment, those sentences will be consecutively served. That's mandatory, not the court's decision. Yes, sir. You understand, and I don't know anything about your case. You know, I don't know anything until it's revealed to me in the courtroom of what I can read in the indictment. But do you understand that there may be defenses that you may have to some or all of these charges which require the presentation of testimony, of documentary evidence, of other proof, or of testimony of witnesses? Yes, sir. And legal argument as well. Yes, sir. If you're found guilty of one or more, no, that's not right. If you're found guilty of more than one of these offenses, the court could order that you serve all of your sentences consecutively. That is one after the other. You understand that? Yes, sir. Attorneys in what I call a capital case, that's a case where the state seeks to impose a death penalty on the defendant if convicted. Those lawyers are specialists who have more knowledge and more experience about this specific kind of case than anyone else. Do you understand that? You understand that not even all lawyers could qualify to represent you in this case. In fact, there are very few lawyers who qualify to represent you or any other defendant in this kind of case. That is a capital case. You understand that? Yes. You understand if you represent yourself, you're on your own? Yes. You understand that the court, neither the court nor anyone else can tell you how to try your case or advise you on how to try it. That is, unless the court appoints. What we call is advisory, or we call it elbow. That's kind of slang. Elbow counsel means that they sit beside you and advise you, but they do not take any part in the proceedings. You understand that? And I can't tell you how to try your case, or if you're going off the rails, I can't bring you back on. You understand? There are pretrial motions, and you've heard some of this going on this morning, and other procedures involved in the capital case. I would say, Mr. Drummond, this morning we have barely scratched the surface of pretrial motions, of defense tactics and maneuvers and strategy in order designed in order for you to be able to defend this case. Some of the proceedings that are going to occur may not occur in the courtroom. That is, when your lawyers ask me to appoint an investigator, a mitigation specialist, a psychiatrist, anybody, any expert in your case, those matters do not occur in the courtroom. Those matters are done by rule. Ex parte, you know what ex parte means?
Out of the court.
It means just them and me, or just you and them. Understand that? And the other side does not get the ability to participate. You understand that if you have to make an ex parte request of me, that you've got to follow all of the appropriate Supreme Court rules and all of the statutes that apply to that. You understand the court cannot help you, will not help you with those matters. Understand that? Are you willing to give up your right to have an attorney draft documents for you? Which part of that, Mr. Drummond, do you think you're going to do better than a lawyer who specializes in capital cases at?
Better?
Yeah, better.
I don't know if I can do it better than the lawyer, Your Honor, but there's things that I've asked to be done that have not been done.
We're gonna come to that in a minute, okay? And I appreciate you bringing that up. We'll talk about that in just a moment. If you do not believe you can do this better than lawyers who have anywhere from 20 to 40 years experience, I'm guessing, Mr. Ferguson. How many years you have? 26. Mr. Huffman?
22, Judge.
Okay, so 48 years combined experience. If you don't think that you can do this better than the lawyers, why would you want to try? Why would you want to just throw away the benefit of the advice they give you and the ability to assert defenses, to advocate on your behalf? And I understand that part of this is you're not getting your way so far. They're not paying attention to what you want. But I also got to tell you, when you have a lawyer representing you in a court proceeding, you're not renting the lawyer's law license. They are obligated under Supreme Court rule to exercise their independent professional judgment. And they do that so they can keep from doing things that would be potentially harmful to you, that you're not going to be able to recognize as it goes. They're going to be able to do that. If I ask Mr. Huffman and Mr. Ferguson, number one, to get your consent before they agree to something, what about that? Would that help?
I believe the damage has been done, Your Honor. There's evidence that can no longer be recovered. There's motions that have already been confirmed by the court to put in place.
What would you have done better on any of those motions?
I wouldn't agree to a gag order or a protective order. I would have at least argued.
But you understand they're trying to get it undone, get it modified now. You understand that? They're doing that on your behalf. And I see this morning you've duplicated that motion, but they've already filed a motion. And that's one the court takes seriously.
That's another thing, Your Honor. Wasn't made aware of any of these motions that were referred to. I didn't know what motion we were going to hear.
You were in court here the last time.
Yes, I knew.
You not received a copy of the motions?
Not all.
And that makes you want to just not have a lawyer at all, rather than get the copies of the motions and motions that are filed in the future so that you've got the benefit of that, so that you can have some input. Is throwing your lawyers away better than keeping your lawyers and trying to develop a better, more open, more communicating relationship?
I just don't believe there's, I believe the trust isn't there.
Trust takes time.
I don't have a lot
Have you read the rules that deal with the criteria for requesting funds for expert services? Do you know what a mitigation specialist is?
Yes, Your Honor. I wouldn't be presenting litigation evidence in this case if I was convicted.
What about a crime scene expert? You got access to a crime scene expert?
I will be looking to implement a crime scene expert and pathologist.
How are you gonna accomplish for independent forensic testing? How's that gonna happen on your own?
Well, I believe my investigators can handle part of that.
You understand, if you don't meet all the criteria, and I can't advise you about it, that you're gonna be denied.
Yes, Your Honor.
You're gonna get denied. You understand the logistics and the communications that are gonna be required to retain and consult with an expert?
Yes, Your Honor.
No, you don't.
Are you able to follow the evidentiary rules for presenting expert testimony and opinions?
No, you can't.
Well, you told me you hadn't studied law. How about the rules of evidence? Have you had a look at those recently?
I have been studying the rules of evidence, criminal procedure, and Supreme Court cases.
What?
Do you feel like your knowledge of those rules is superior to 46 years, 48 years worth of legal experience?
Absolutely.
So
Let's
again,
go back and
you're
hear what he said there.
Follow the evidentiary rules for presenting expert testimony and opinions?
Yes, Your Honor.
Well, you told me you hadn't studied law. How about the rules of evidence? Have you had a look at those recently?
I have been studying the rules of evidence, criminal procedure, and Supreme Court cases.
I have been studying the rules of evidence, the rules of criminal procedure, and the Supreme Court rules. Is what he said.
Do you feel like your knowledge of those rules is superior to 46 years, 48 years worth of legal experience?
Absolutely.
So again, you don't think you're going to do this better than they would?
I don't doubt their ability to be lawyers at all.
But you still want to give up the right to have that help, to get those experts funded and working for you. And you want to change criminal investigators, I understand as well.
Yes, Your Honor.
Am I right? You want to give up the right to have them do that part of this case for you?
The ones who are currently employed, yes, Your Honor.
Are you able to hire counsel?
No, Your Honor.
Such a bad
Do
decision.
you understand the types of questions that are going to be appropriate and inappropriate to put in a potential jury questionnaire?
Loosely, Your Honor, but I will continue to study the law library to have better knowledge of that.
You have access to the law library where you are now?
Yes, Your Honor, that's the only thing I'm able to do on my tablet.
You understand? You're able to do that on your tablet?
Yes, Your Honor.
You understand, I can't advise you about the rules of criminal procedure, the rules of evidence, or the Supreme Court rules on obtaining expert funding.
Yes, Your Honor.
Can't advise you on the rules of evidence. You understand that as well, sir?
Yes, Your Honor.
So tell me what you think happens if the jury were to find you guilty first degree premeditated murder. What happens next?
I'll be sentenced to death.
You understand that there's a second trial.
Yes, Your Honor, I would waive that and allow you to sentence me.
You would waive the right to present evidence to a jury in the hopes of saving your life.
Yes, Your Honor.
How is that better than trying the case? How's it put you in a better position?
Well,
Why is waiving your right better than exercising your right to have the jury make that decision?
I believe that's my right to make that.
Why is that in your better interest? I'm curious.
If I was to be found guilty, Your Honor, the conditions of death row are much better than they would give a life in prison.
But you understand what a death sentence means.
Yes, Your Honor.
You understand you have the right to testify during both the trial and the sentencing hearing afterwards.
Yes, Your Honor.
You understand that you may not be able to just take the witness stand and just start talking.
I was made aware of that today, Your Honor, yes.
Does that impact your decision at all?
No, Your Honor.
What? Facts, Aaron. Facts. Did he
The
judge tell him that yet?
filed a notice indicating, Mr. Drummond, that they're going to present evidence of these aggravating factors. One, A, that you were previously convicted of one or more felonies whose statutory elements involve the use of violence against a person. I suppose that would be the aggravating robbery, at least at this point. B, that you committed the murder of more than 3 persons within a single episode or at different times within 48 months. C, that the murder committed was done so in the course of an act of terrorism. I'm not saying whether these are right or not right. I'm just telling you what the state intends to prove. Fourth, that the murders may have been committed at random, and the reasons for the killings are not obviously or easily understood. You understand that part?
I understand that. I remember you saying that better than
What?
For the killings are not obviously or easily understood. You understand that part?
I understand that. I remember you saying that better than
Anyone make that out?
You don't obviously or easily understood. You understand that part?
I understand that. I remember you saying that better than
But I think he
You're
said,
telling me you don't,
I think maybe the judge is about to repeat it, but I also understand that they said there's no clear motive, which is what his issue is, that he had no motive, so that his self-defense claim makes, makes more sense because he loved these people,
would not want
although he was snitching on them.
to participate in the Senate. You understand that part?
I understand that. I remember you saying that better than
I remember them saying
But
something
you're
about,
telling me you would not want to participate in the sentencing phase of the trial at all. You would want to waive that.
Yes, I'll focus on
Whether that's permissible or not permissible, you want to waive it because you believe that you're right.
guilt innocence is all I'm concerned with.
maybe that's going to help the judge
You
say,
understand if you
I'm wondering if that might help the judge say, like, you clearly have no understanding of the law. You can't just waive and go to accept the death sentence. At least I don't think so. Maybe you can. I don't know. Actually, strike that from the record. I didn't say anything.
you're right.
Guilt innocence is all I'm concerned with.
Guilt or innocence is all I'm concerned about, Your Honor.
You understand if you represent yourself, I can't guarantee you have access to a law library. That's not a guarantee the court can make.
I was unaware of that. I am now. I'm aware of that.
Once the trial is scheduled, Mr. Drummond, unless I determine there's a need to continue the trial, you'd be expected to proceed when the trial begins. You understand that?
Yes.
You understand how to get a subpoena if you want a witness to appear at a hearing or a trial?
I understand. Believe the court.
You understand that'll be your responsibility, nobody else's, for yourself.
Yes.
If you represent yourself, you understand you'll have to abide by the court's rules regarding courtroom behavior. and that you may only address me during the proceedings unless you are making an opening statement or a closing argument to the jury. You understand that during a trial or any other proceeding, you may not freely communicate with persons in the courtroom. Okay, you don't have access to them. If you represent yourself, you will not be able to claim in an appeal.
There you
that
go.
Your advisory counsel was ineffective. You understand? And you cannot claim that you were ineffective at representing yourself. In other words, those claims that we call post-conviction claims for ineffective assistance of counsel are gone. You understand that's a significant deal.
Oh my gosh.
You understand that almost 100%
Yep.
capital cases wind up in a post-conviction proceeding involving a complaint or an assertion that counsel was ineffective. Almost every one of them end up there. And you understand you're giving that up if you represent yourself.
Yes,
When thought about that, have you?
I'm not thinking about it.
What? I'm not thinking about what? An appeal, Your Honor. That's what he said.
Another dumb question.
He said, I'm not thinking about an appeal, Your Honor. Like he is convinced that he is going to be able to prove self-defense at trial, despite his inability to put on witnesses, to put on an expert, to know how to present evidence, to know how to lay foundation. I mean, it would be a fucking miracle if this guy is able to ask questions that are not objected to and, present evidence. I mean, I don't know. Do they have Chat GPT in there? He might be able to say, draft me, direct examination questions for my expert. Tell me how to lay foundation. But, the rules, there's different rules in different places. It's not just like you read one rule and it tells you all the answers. It's like you've got to understand the rules and as they apply in different ways and different times, depending on the circumstances, what you're trying to do, the basis of the objection. I mean, this is ridiculous, outrageous. I don't know how I got the hiccups. Again, no food. Can someone in the chat explain that to me? I thought it was like usually had something to do with. All right, let's just go.
And you understand you're giving that up if you represent yourself.
Yes,
When thought about that, have you?
I'm not thinking about it.
Another dumb question. You understand you have the right, absolute right to be represented.
Yes,
You understand at the trial you have the absolute right to testify, which you also do. You understand that nobody can force you to testify, whether you have 10 lawyers or 0 lawyers. That right to have a lawyer to represent you is on every day of court, every stage of your case, every day of trial, every appeal, every post-conviction proceeding that you're otherwise going to waive if you give this up. You have the right to have a lawyer represent you. If you get in a bind during trial, you don't know how to object, how to fix something that's going badly, you know you're going to be held to the same standards as a lawyer, as 28 years of experience.
29, I think.
The court cannot provide special or preferential treatment to you because you represent yourself. Understand?
Yes, sir.
If you introduce evidence in a way that does not comply with the rules, the court is not going to permit you. Understand that there's no, I'm doing this by myself, I'm not real sure how to do it. You understand that? That's not an option in this case. Mr. Drummond, you absolutely would be better served by being defended.
Come on, change your
by a
mind.
trained lawyer who qualifies to assist you in this kind of case.
Yes, just ask
than
for
if
a
you
different
try to
lawyer.
represent yourself. I think it's unwise of you to try to represent yourself, although you are looking at the law or familiar with the law from
Not the
sitting in
same.
your own trial as a juvenile. I just don't think you've got the experience, the wherewithal, the ability, the access to the resources that you need in order to waive your right to counsel. My little script says, I strongly urge you. I beg you.
Yes.
I beg you not to do this.
Oh, man.
It is not in your interest. It is not going to end well. Do you know how many people who represent themselves are convicted?
100%.
Have you taken any medication today? Do you take any medication? Are you under the influence of any substance at all today, sir? No. Is there anything affecting your decision to want to represent yourself other than what you have told me in your motion and what you've told me while we've been talking today?
So I see some complaints about the sound. I think what happened is the judge just got very serious and he's like, he's talking with a soft voice. He's literally begging and pleading for Austin to not do this with everything he has. So he's using sort of his like soft emotional voice being like just begging him. It's just, this is so horrible.
So I look at your motion and you give me 10 reasons.
All right, so this will be interesting, everybody. We went over the motion in our last live, and we went through why some of what he complains of is wrong. Doesn't matter. It's the lawyer didn't do anything wrong. And so the judge is going to go through now the 10 things in his list of things he's saying my lawyer wouldn't do this, my lawyer didn't do that, and he's going to go through them all. So, unless I don't know, anyone can find somewhere else that this has got better sound, I think this is all we have to deal with. I checked Court TV, they still don't have anything. And I do know that so when I talked to the court, they said that there is one pool camera per the order on this case, like the judge's order. And then each of the news stations, they decide amongst themselves which station is actually going to be the pool camera. So I don't think it's going to change on any other feed. I think this is the same no matter what because we're on using the same pool unless somebody has the ability to boost, which we did have when we were using the YouTube version, but I did go back to YouTube for this station and I still don't see it up. So we're stuck on Facebook and that I cannot boost. Wait a second. Let me try this. I don't think that that's gonna. I think this is the same thing where I'm always saying it only boosts it for me. Use this to control the volume of the current tab. All right, boost this one too. And maybe I'm getting insanely loud right now for you guys. I don't know, but let's see if this makes any difference. Okay, so for me, it's loud as shit, and that was just like the little fuzz behind. So I'll play it again and see if you guys hear any difference, but in my experience, it only makes it louder for me for some reason. But I'm gonna hit play again. All right, so here we go.
I want to go through them. the first round of reason you gave.
All right, so I'm coming back, you guys. Is that sound any different for any of you? Because it's blowing out my ears. And I can turn my volume down. Oh, and turn your guys's up. It did get better? Okay, I'm going with no, because if it's a little better, then it's really not, and you guys just think it is, because that it's blowing my eardrums. So how do I turn this off? All right, turn that one off. Put that one back. Okay. Now I'm going to turn my sound down. I always forget to do that, so you guys can crank yours up as high as it goes. And if Bob comes back, we'll have him crank his down. Oh, settings. I have mine down. All right, I'm cranking mine down a little more. Cranked mine down to 26. So if I'm too quiet, let me know and I'll put it back up. But I was still down from last night. All right, here we go.
Was that during the preliminary proceedings, and I assume you mean the preliminary hearing, right? You asked for the 14-day rule not to be waived, but Mr. Huffman disregarded that and waived it anyway, right? And that didn't cost you anything,
right?
It cost a month. The indictment was a month later.
But
I'll tell you, the grand jury in Lake County didn't meet in November. They don't meet in October. They don't meet in September. They don't meet in August. Secondly, you say during the preliminary hearing that Bryan Huffman failed to object to hearsay. You told me you didn't read the rule of criminal procedure. You didn't read the rule that says hearsay is permissible in preliminary hearing.
Not all.
You also don't understand the strategy involved by an experienced lawyer. Understanding the case and knowing that every available piece of information that he can get committed to the record, he or she wants in that record, so that you know exactly what you are facing. You understand that? That is a matter that experience in the law, experience in trying cases, experience in representing defendants who are charged with crimes brings. And that's the experience that you had the benefit of that you now complain about, not understanding that that was ultimately something that was being done to help you. And I know you didn't understand. I'm not lecturing you because you didn't understand. But I'm telling you, that's not a reason to fire your lawyer now, that you understand the strategy involved there.
Your Honor, I just want on the record, I don't believe for a second he's incapable. I think he's a great lawyer.
When I'm looking at the grounds for your motion, that is your complaint, not anybody else's. I understand you think he's a great lawyer, but you complained about that, not understanding that he was being a great lawyer at that moment. And he didn't ask any questions, you say. Did not ask questions requested by you concerning motive. You understand motive is not an element of the crime that you're charged with. Motive, not an element. Not a defense, not an element. Now, it may be self-defense. That's not a matter for today, and it wasn't a matter for the preliminary hearing. And you say in here they agreed to a gag order without your consent. I understand that part. I've got you on that. They agreed to a protective order without your consent. I don't think he was given an option in that protective order. I don't think he was given an option to consent or not consent. And frankly, he wasn't given an option to consent or not consent to the gag order, because it wasn't anything that he had been involved in that caused the issuance of those two orders. I don't think this court issued the gag order. I think that was done in general session. Still applicable. In August, you wanted phone records to be subpoenaed. That would be after your preliminary hearing. before the preliminary hearing? You wanted phone records at the preliminary hearing?
I want to do that, this needs to be for the next, I know it takes time to get them, so, but I know that at the time they go away, so.
You say in November 2025, you gave him valuable information to pass on to investigators? That's after your preliminary hearing,
That was at the arraignment,
at the arraignment? Thank you. Which was
November 17th.
17, November 17th.
He knows his case.
Bryan Huffman told you he would address issues with court on March 24, did not address those issues. Your lawyers repeatedly pushed court dates off to later dates against the wishes of the defendant. I think we were set before, and I had a problem. One of them is my fault. Okay, one of them is my fault. The other thing is that I can't impress on you enough the fact that this kind of case moves at a snail's pace. It is not like your other cases that you have. It's vastly different. It takes longer to get prepared. You mentioned a minute ago phone records take a long time, and that is such a minuscule part of the potential proof, potential defenses, potential strategy that takes literally years to develop there to maximize the best outcome for you. All of that. So I don't know if it's a problem, a lawyer problem, or if it's an expectation problem on your part. But the lawyer can't fix your expectations, and the lawyers cannot speed me up. Mr. Drummond, is there anything else you need to tell me? Has anybody forced you or threatened you or tried to coerce you into waiving your right to attorney? Is your decision to waive your right to counsel entirely voluntary on your part?
Yes, sir.
Ms. Ferguson, I put you on the spot. And if you don't have anything, that's fine, but do you have concerns about Mr. Drummond representing himself?
On capital case, you want to do the attorneys, not handle capital case, take specialized training. We rarely see these. Took a number of first-degree murder cases that we handled before we became qualified. The Rule 13, it's not going to understand Rule 13. You'll never get a Rule 13 filed correctly. It doesn't understand the distance rule under Rule 13. We have trouble finding forensic pathologists. He's got limited access to a phone. He'll never get a forensic pathologist. Again, he's feeding house and he'll have the same problems, same conditions. He now knows what the aggravating circumstances are, but he's not expressed the fact that he even knows that he can attack those through trial. He also doesn't understand that he can mitigate his prior conviction. So, but again, he's already said he's waiving his guilt in his life-death trial. So then if he trusts family and has heart case, and the court might use it when it's necessary, he's not going to use it. So that becomes a real problem, because in the Tennessee law, it's one of the few rights that the defendant has. Everything else within the trial, plead guilty, not guilty, jury trial, bench trial, is on a death case. The defendant does have an absolute right, as well as the attorneys, not to put on any proof for like death. There's a consideration that's going on, or a problem that's going on right now.
Wait a
The defendant does have an absolute right.
All right, so I'm just going back to hear what he says about having an absolute right on the death case. It sounds like he might have the right to not fight life or death, but the state was saying that He's going to have a really hard time finding a forensic pathologist. They had a hard time finding a forensic pathologist. He's going to have a hard time with other experts as well. He talked about a Rule 13 that is very difficult. It's not, I think that is when you're, okay, so I think Rule 13, if I recall, and he did mention distance. So you have to, if you're going to get funding for an expert, and so in a pro se case and even otherwise, there's a distance requirement. The expert has to be within, I forget the distance. So that's why he's saying it's going to be really hard to find an expert. He has to figure out how to get around that or what to do. He's not going to know what to do. And now he's talking about the waiving of his death penalty, of the sentencing aspect.
That becomes a real problem because in Tennessee law, it's one of the few rights that it has. Everything else within a trial, other than pleading guilty, not guilty, jury trial, bench trial, is on a death case. The defendant does have an absolute right, as well as attorneys, not to put on any proof for like death. There's a consideration that's going on, or a problem that's going on right now in Riverbend. So you've gone on for several years, the evidence out there that when you get people that go out there that shouldn't be, or they come back on post-conviction or in post-conviction, which happens all the time in death penalty cases. There's so many ways you can do it wrong, especially when you speed it up. That's why we take these things so slowly and try to stop and backflow these cases back into post-conviction. It's that they get out there, they're told by the other inmates that, oh, waive your life death because you want death penalty because then you get all these extra services moving forward. And unfortunately, he's in the mindset of just wants to waive everything. So I don't think we.
Oh, Lord. Now what? All right, it went off for a minute. It's about to come back on. So what he was saying there I just paused it. It's about to come back on. Was that he does have an absolute right to not present any evidence on the death penalty, that, there's inmates in jail that tell them just waive your, the death penalty and accept it because then you get all these extra benefits, because when it's a capital case and you could be getting the death penalty, you get all these extra benefits. But I think you get all those extra benefits without needing to waive anything unless he's worried that he wouldn't get death. And then if he had to go to post conviction, he wouldn't have all those extra services. But this is not a case where you're not getting death. If they find that he intentionally cold-blooded murdered 4 family members, including a 15-year-old, that he's getting death. He's getting death. That's what I think anyway. So I don't think it's a concern. But that's the other thing that he's saying, is that these inmates, try to suggest they do that because then they're going to have extra resources available. And that is true. When it's a death penalty case, you do have extra resources. You get more money, you get more experts, you get more help. Da, 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 da.
They have all those. No, yes. I think that was important.
This is a death penalty case. He will have to pick a death penalty jury. That, in and of itself, as far as hard things go, it's a different than picking a regular jury, and so yeah.
In any other case, I would say that he's probably age young, and I've had conversations with my clients before. I will let them know what they need to say to the judge, what the questions are, if they want to represent themselves. I have no problem with somebody representing themselves. It's a constitutional right, but that's a right that has those kind of bumpers on it. It says that the court, only the court, can make a determination whether or not he's really capable of performing it efficiently. And again, you can't help him. We won't be able to help him. And that creates a huge problem when it comes to the situation sets up that this is the approach. The communication is difficult because it's out of Riverbend, it's far away. They don't allow them a lot of phone calls, and that's probably something that we should start addressing. He's been seen by litigation specialists, seen by investigators. I've seen him out there, but it's just not. It's not enough for him. And again, that's part of that manipulative. Is that he wants to be from letting people learn how to do things as opposed to letting professionals be professionals. So I find this one probably falls on the side of counties just because of the difficulty and the enhanced amount of law that we would have to navigate successfully to be with the correct teams. Attorneys can't do that. How can you expect them to do it?
Thank you. Mr. Huffman, anything to add to that?
Judge, I would echo Mr. Ferguson's statements. The biggest issue is I don't think he understands what significant challenges he's going to have going forward in trying to represent himself. Mr. Ferguson said, it takes, he's angry about pushing hearings off. We've only been here twice before. This case is normally take 18 to 36 months minimum before we even get to trial. And that's with us being out, working with investigators, getting mitigation specialists, getting crime scenes, all those experts that you're talking about. We are able to come to you and get these things ex parte, or even working with the district attorney. We're not locked up in Riverbend with minimal phone privileges and access to a law library on tap. I don't think he understands exactly what he's giving up when he's doing this. I get he's frustrated with the situation and not being able to review discovery. We're working on that. But I don't know that that is enough to show that he understands what he's giving up, because he's mad about not being able to get discovery, or mad about the conditions where he's being housed. We don't control those things. He doesn't understand that when he represents himself and we're off the case, he is literally on his own. He's a man on an island with no access to any realistic resources, the ability to continually get with the district attorney, meet with witnesses. If you get an investigator, again, he wants to relieve the investigator we do have, who's very capable and has handled multiple death penalty cases. How's he going to research investigators? How's he going to research and get experts? He's at an extreme disadvantage. Not to mention this is a capital case. It'd be really uphill if it's just and I hate to use this term, but one of the Bill murder case. Murder case, somebody's lost their life. They're very difficult in this itself. This is a capital case. And he's already indicated that, I'm just going to wait my litigation. There's a lot that goes into that, a lot of consequences.
Yes, sir.
The experts that are retained or about to retain, have been retained, all indicate that we're not working this person.
Mr. Huffman, you've heard a couple of the complaints that Mr. Drummond voiced involved agreements or concessions, none of which the court has heard with prejudice in any way. But I think, as you say, being stuck at Riverbend and not having access to you, would you all be willing to make your best effort in terms of communications before you commit anything?
Oh, yeah, yes, sir. The ones he mentioned in the motion, they're in the gag order and the protective order. We did discuss that with him. And I did explain to him, without getting into the attorney-client privilege.
Right, I don't want you to.
The court has already indicated that I really have a choice. Those orders were coming forward regardless.
Well, I don't know about the gag order, but I do know about the protective.
Yes, sir. So those are some of the things. The other
I think
issues.
I told you and the state to come to terms on one
Yes.
because one was going to be in it,
Yes.
is my recollection.
Yes.
And so to the extent you conceded, he was under the duress of,
Thanks.
but he's concerned about about knowing what's going on as it goes.
Yes, sir, and we understand that, and part of that is been the difficulty of just being able to get, we have to physically go there, it's a 7-hour round trip just to get there and meet with them.
I understand.
There. The other part is we have to schedule Zooms, and they're limited in scope and the number we can get.
Do you have a length of time that the Zoom is limited to? Are they using Zoom or some other?
They're using Zoom.
Okay, or do you have a time limitation on the duration of the meeting there?
There
You
are.
know what I'm asking?
Yeah, yes, sir, there are, but we are able to reconnect, so time limitation itself is not an issue. Because again, those are like 40 minutes or whatever, cuts off, we're able to reconnect, so we get an additional 40 minutes. But
Let me ask you, Mr. Drummond, does the facility limit how long you can use the Zoom?
Then, it's a 40-minute call, and then they allow you to call back,
Okay,
but they stipulate depending on their staff, on whether or not they have staff.
available staff.
Yes.
Gotcha. Is staff in the room with you while it's going on?
They have been, they keep the door open, so they listen to what we talk.
You think they're able to hear what you and your lawyers talk about? Lawyers are nodding in affirmative there as well.
Yes, sir.
All right, thanks. I appreciate the information.
You're muted, babe.
Thank you. See, he's in the background watching and listening. I am so glad that this judge is like really taking this seriously, really taking his time, really trying to like address what Austin's concerns are, just hoping in his heart of hearts that this is going to change his mind or that he can say, well, based on everything you said, I feel like we need to give this, another 45 days, I don't know, 60 days, whatever it is, for to see if these changes take effect and you're something like that. He's doing like so much and I'm so appreciative of that because this is the worst decision out of a man and a man child who has made a ton of bad decisions in his life. There is nothing that even comes close to the insanity and stupidity of this request. So let's keep going. Thanks, babe.
Also, we were right outside.
Affirmative there as well. Okay, all right, thanks. I appreciate the information.
They'll also be right outside the door where they can easily hear. If it's,
Yeah, he said the door's open, he doesn't have,
Well, if it's in person, attorney.
even in person.
They're putting this, the first time I went, they put us everywhere they should have put us, which is face-to-face. We're not separated by class. Went with the investigator and they put us in one of those little rooms with big glass and you have to lean right up on it.
Right.
And yell at each other, but we can hear the guards at the front door talking, which means they can hear us talking.
If the court were to grant the waiver, the court would appoint advisory counsel. Whether you choose to utilize advisory counsel strictly would be up to you. Understand that? Yes, sir.
God, please don't judge.
I want to think about it a little bit. We've covered a lot of territory in the last hour, and I want to think about it a little bit. I'll issue a written decision on the motion to waive right to counsel there, and I'll do it relatively quickly.
I thought maybe
I
goodbye
have a
to time.
proposed jury questionnaire from the state. Have you all had an opportunity to review?
I reviewed the judge, and we've actually prepared one. I just need to get that. Mainly, they're mainly similar to this condition, just slight changes.
When do you think you can get me a draft?
By next Friday, Judge.
And will that be with Mr. Drummond's approval?
I will get that to you.
Okay, I'd like to have his approval, before you submit that to the court, as to the format.
Yes.
Okay. That'd be by the 22nd,
When you say his approval, can you with the objects?
his review.
Just that he reviewed it? Yes, sir.
Ultimately, the court's gonna make a decision about the content. If he wants to object, that's okay too. No, I don't have a problem with that. I'm gonna make the final decision on the content of I thought the state's was was thorough. And if there are other things you need to add or take away, I'm open to listening.
Thank you.
Yes, sir.
Your Honor, could I get clarification on one matter?
Yes, sir.
In regards to the protective order, when it comes to handwritten information that I've given to my lawyer for investigators, or just anything that I've given, or anything that's coming from the defense and not from the state, is my lawyer allowed to give you copies of that?
Of your own work, of your own documents?
Yeah, nothing that's coming from the state.
Yes.
Look at him. Look at his lawyer.
However, if I see it on something.
Oh, sorry. I meant to mute myself, and instead I paused it and coughed extra loud in everybody's ear. Sorry about that.
Of your own work, of your own documents?
Yeah, nothing that's coming from the state.
Yes. However, if I see it on social media, or if I hear about it, we don't have a problem.
Yes, sir.
And I need you to tell me. Okay, I'll be looking for a questionnaire sometime on or about the 22nd. I'm gonna hold you that day.
Yes, sir.
Because it's the start of a long weekend, so.
Yes.
We've got we need to talk about an appearance date for next round of motions. If the court permits Mr. Drummond to waive counsel, he has filed a round of motions today. There doesn't need to be, maybe need to be taken up at that point. If the court denies the motion to waive counsel, then we're not going to take up pro se motion. You either have a lawyer or you don't. There's no, of course, not going to permit a hybrid representation model in this particular case. We got a pre-trial conference at May 26th and we're going to move that one, right? You think?
Yes, sir, we've asked.
Yeah.
that, yes, sir.
So, what, do we have a potential day for that right now?
We didn't suggest today, but
All right. I don't think I've suggested one here. I thought I had written a day down, but I was thinking about it. Which was potentially June.
it's going to be here June 22nd. I think that's regular day too.
It is a regular day, and I don't think I don't remember what day it was. Wherever I wrote it, I can't put my finger on it right now. So. Mr. Drummond, you provided an address in your motion to waive counsel. Is that an accurate address for you as of today?
Yes, Your Honor. Both my name and the number would have to be on there.
Right, I understand. I do understand that. All right, we'll set it, we'll get another date set for next round of motions. And at that hearing, we will start talking about trial date and the date for a re-notice, those kinds of things.
Your Honor, is there a deadline for the next round of motions?
I have not set one yet, but I will do that in writing.
If I could get notice of that.
Yes, sir.
Thank you.
I'll be glad to provide you with a copy of that order, setting the appearance date. And generally speaking, motions are due about 3 weeks before the hearing. It gives the other side an opportunity to respond in writing. Okay? And we'd like all responses to be in writing in this particular case. From the state's perspective, is there anything else we need to take up?
You know, we had strings out for Verizon. I'm ready to see see it shaking. That's I thought that would be fat, bigger than the last time I saw it. We'll pick that up.
Okay.
Thank you.
Very good. Anything else? We're going to recess so that Mr. Drummond can be returned. I'm going to deal with the individual that we're hearing from the courtroom.
All right, we have to hope that they don't cut this feed because I would love to hear that. And if anybody out there can find somewhere else that this is streaming, just in case they cover that next part of this hearing, that'd be amazing.
So this being a recess for about 5 minutes, he's good to go.
Change your mind, Austin. Change your mind. What do you guys see body language back there? Like he's trying to get him to change his mind? I don't know. I couldn't tell. They're following him. Oh, let's see if they stay.
Sir,
There we go.
James, if you would.
Take it easy on him, Judge. He's grieving.
Mr. Wilson, are you a family member of the victims in this matter? Yes.
He's using his soft voice, so that's nice. The judge.
Anything you want to tell me?
I'm sorry. I'm sorry to the court. He's getting by, you know, he's wanting lens in. Me and my kids and my family, we don't get nothing. Even if y'all put him on death row, he gets nothing compared to we never get to see our child again. My granddaughter has to grow up with no parents, no grandmother, no uncle, because Austin killed him.
Mr. Wilson, let me talk for just a
Yes.
minute. I appreciate you telling me that you're sorry, but you understand you disrupted the court.
I do.
And that, in my view, has nothing to do with who's sitting over there at that table. It does to you. I want to tell you, I'll tell all of you all. I understand. I understand why you feel and why you felt the need. I do. I understand. But we don't do court. And that's what I've got to be, that's what I got to worry about. I've got to worry about the way this court goes. And we don't do that. You can't do that. Okay?
I promise it will not happen again.
I'm not going to prevent you from coming back.
But I will
under
do it
that
again.
promise. And here's what's going to happen today. Okay? you're in contempt of the court.
No.
You committed an act of contempt in front of the court, and the court's gonna fine you $10. Yes, sir.
Okay. I take it.
Wilson, if it happens again, there'll be 10 days in jail. Okay. Is that enough of an incentive for you not to scream curse words in the courtroom?
I wouldn't mean to be disrespectful to you or anybody else.
I accept your apology because I understand the emotion behind it. Okay? I accept your apology. You're sincere with me, and I know this is not you. Okay? We pay the clerk $10, and the next time we have a problem, it can be uncovered. I'll write up an order that indicates he was found in contempt and fined $10. Anything else? Okay, we're adjourned.
Thank you. All right.
Oh, Lord. That's just so devastating.
Are they taking him into custody?
No. No. We're just listening now.
I forgot I handed it to you.
We gotta give that lady $10.
Or he just paid.
Probably worth it. Probably the best $10 he ever spent.
Oh, a family member over his shoulder paid it.
Right? Pretty well spent $10.
Yeah.
Get to air your shit out. I mean, when else is he going to get the chance to do it?
Right. That was heartbreaking. Oh, what?
Oh, you look so big and beautiful.
Jeez. Wait, where's the regular 2 people thing?
Oh, right here. Boop.
Oh.
Hi there.
Wait, hold on. Okay.
Oh, hi.
That's better.
Oh, yeah. You're so beautiful.
Um,
Wow. That was,
I think we gotta put our mics back up.
yeah, I'm low. I cranked. I
too.
heard you saying that you thought that might help with the volume. I put mine down to 22.
All right. I hit automatically. So guys, adjust your volume accordingly.
Yes, I did the same. And I have a
Okay.
big mouth on top of it.
He does.
Yeah, so what is he gonna do? Like, is he granting him the
He might.
ability? He
He
took it under
might.
advisement.
Yeah, I was kind of hoping that he was, after all that, going to be like, are you still sure? And how about we give this 60 days while your lawyers try to make some changes that adjust, but the lawyers got this motion and nothing changed. As far as I know, nobody went out to see him. Nobody called him anymore.
Yeah.
I understand that it's like they go out to see him, it would have just been hand holding because they don't want to talk about anything while the deputies or correction officers are standing over their shoulders. I promised you guys an update.
Yeah, I've heard Austin speak enough, either in his statements or in open court, to basically realize he's not a stupid person. I mean, he seems to be of reasonable intelligence, and I understand that he can, read law books and think that you have an understanding of the law to some extent. But what the judge was telling him with respect to being a trial lawyer and understanding how to get things into evidence and how to keep things out of evidence and how to cross-examine and how to impeach and just all the things that you need to understand in order to properly defend yourself in a death penalty case.
Yeah.
I mean, I wish I could get in his ear.
I
I'd be
know.
like, yo, dude,
I
no,
know.
this ain't it. I hear what you're saying. I understand your frustration. I look, because none of us were there. I mean, none of us were there. We don't know what happened. We know what the end result was, and it was horrific. It was tragic. 4 people lost their lives. Fortunately, the baby survived it, and it's a horrific case. However, until we hear the facts of what went down that day. But it's like TV Trial World was saying, you know, it's like how, like I'm trying to work out in my mind how it works in terms of a self-defense case when you've got 4 people who were killed. You know what I
Okay.
mean?
So let me give the background and then I'll answer at least what I know on that issue. So again, and I am reading from I asked Grok to only go based off of my posts that I have made and the information that I provided and like give it to me all at one spot. So I'm gonna read it. So on July 29th of 2025, 4 members of the same family were shot and killed. Courtney Rose, 38, her daughter, Adriana Williams, 20, Adriana's son, Braden Williams, 15, and Adriana's, this says boyfriend, maybe they weren't married, but that's Matthew Wilson, 21. That's whose father, I think that it was Cody in Tennessee said that was his father.
Yeah.
There's a 7-month-old infant, the daughter of Adriana and Matthew, was found safe in a car seat on a stranger's lawn miles away in Dyer County. So I'm just going to pop in now because we know with that, Austin drove the baby to this house, honked the horn, made sure that somebody attention was drawn so that somebody could care for the baby. I mean, otherwise he could have stranded the baby there with everyone, you know, and it would have taken days because we know I don't know how much longer it was, but there was days of a manhunt. Maybe someone out there knows how long it went on before they found that crime scene and would have found that baby. Okay, so Austin Drummond, 29, was arrested after a manhunt and charged with 4 murders plus aggravated kidnapping for the baby. He faces the death penalty and has pleaded not guilty. Austin had a prior aggravated robbery conviction from when this says much younger because it couldn't, I guess I didn't post on that. So he was 16 when the crime was committed. 16 on drugs and stole, I swear it was dollars. You know, he either pointed a gun or had a gun and then reached into the register and grabbed it himself. We watched that video of that crime on a previous live. So I remember that. All right, where was I on this thing? Okay. He served time for it and had only been out of prison a year when this incident occurred. So he served 11 years for that. And it wasn't supposed to be like he was, I think, already agreeing to cooperate, was promised that he wasn't going to go to juvenile, all these things, and none of that happened. Okay. He was romantically linked to a member of the victim's family and had been close to the victim's family. They even described him positively in statements. I wished it would have been more specific.
I mean, she was a corrections officer. She worked in the prison.
I think that was her. And Grok.
Well, I mean, I think that's who he had. You know, she got pregnant, I think, by him.
Yes, you're right.
Yeah.
And I wish Grok would have been more specific because there was, and I think we went over in a live as well, but in the death announcement, you know, he was listed as, no, even after they found out. So in the death announcement, he was included, or in the death announcement, maybe for their grandmother that happened before this. I can't remember. And then in a statement by the family after he got accused was like, we could have never thought that this guy would hurt anyone, let alone family. We considered him part of our family. So, and again, it's on a previous live, but Grok screwed me by not really parsing my statements, my posts as much as I would have liked. What makes this case especially important is Austin's own account. He has publicly stated he was working as a confidential informant for the FBI. He claims the FBI recruited him after his earlier prison stint to help expose corruption, drug smuggling, and dirty officers inside Tennessee prisons. Details shared in coverage, including open letters and reporting, support that he was indeed cooperating with law enforcement in that capacity starting around April of 2025. Notably, Austin had other charges from his time in prison, drug offenses and firearm possession alleged in July of 2023, and that was charged in November of 2023, and attempted murder of an inmate alleged in August of 2023, charged in November of 2024. Those cases were repeatedly rescheduled with the last court dates in April of 2025, which is the exact date that Austin said he started working with the FBI or whoever he was working. I know his handler was FBI, but I think he was working with more than just that. Um, and that's what the next sentence says. Right when he says he began working as an informant, they didn't move forward until after the quadruple murders. According to Austin's, the victims discovered he was an informant. They believed he had access to money because of that work, confronted him at gunpoint, demanded his money, and planned to murder him right then and there. He has explained the shootings as self-defense. He acted to protect his own life when he believed they were about to kill him. I'm just trying to see if there was anything else that was factual that was included in this. So here's what he says happened. He says that he gets there, he gets out of the car, and I believe Matthew pulled the firearm on him, pointed the weapon at him, demanded the money. He shot at the person holding the firearm. There was the other guy also had a firearm. So both of the males had firearms. One of the firearms, they fired at him and it didn't go off. He fired. He didn't know who else had the gun. Then he fired at I think the one of the females. Then the other male got a gun and he fired at the both of them, not giving anyone a chance to get a hold of the guns that these guys dropped and pick them up and turn around and shoot them. So that's what he says happened. Then he drove the baby to.
Were either of the females armed?
I don't think so, but I don't know. I think it was a question of he didn't know at that point because guns had been, dropped. I think the girl was crawling on the ground near where the guns were. So, I mean, this is a kind of case where you're almost never going to know what really happened. And it's going to be about, specifically as to those two women, whether that's manslaughter or that's murder or that's self-defense. Because like you said, did they have the guns? Was he reasonable in thinking that they could access them very quickly and would use them? I don't know. It's a very unusual fact pattern in that sense.
But
Heather says, and I think I do remember this. So Heather says he said they had him tied up and he got loose. I think I might have talked about that before. This is how bad my memory is. Like I was thinking about that and I was like, was I thinking of another case? Was that me in my head coming up with something? But Heather's saying the same thing. So yes, the 15-year-old definitely had a gun.
Yeah, and we know that the 15-year-old
they were all there to do a drug transaction.
Yeah, they were all there and they had all made the run to Walmart, including some of the co-conspirators that have recently pled.
No, those co-conspirators, I think, all only got involved
after the fact.
Yes.
So I think, Matthew was the one who went to Walmart to buy like the burlap bags or the tarps or whatever, like a bunch of the stuff that they were going to be using for this drug operation where they're going to be using drones to drop drugs into the nearby prison. Like in one of our lives, and there is a playlist for anybody who's not up on this case that's got all of our Drummond lives in it, including this one, where we go through kind of all that background in terms of there was a lot of weird shit going on with this. This isn't like some open shut Austin Drummond just went and killed a bunch of people randomly. Like it's not that.
It's not
what,
that.
What happened is still unknown. Obviously, at this point, all we have is Austin's story or version of what happened. But in terms of him representing himself at trial, the battle for him to be able to get in to evidence the things that occurred leading up to the event is going to be what his challenge is. If that context does not exist, he is screwed, because then it just becomes about the moment in time where it's clearly relevant to me what happened leading up to the event.
And they did say they had multiple spent casings. I forget the right words. Multiple rounds at the scene. So getting a reconstruction person can help some of that. Like if they took the hiccups came back.
Should I put Brent Turvey on it?
Right. Yeah. And no, but where the gun
Turvey's getting all kinds of play ever since he leaked this information.
he did a very good job in his analysis.
For us, he did.
Yeah.
Yeah. Like because we were using him to show a
the same
lack
kind of thing.
Connection between two crime scenes, because we were using him for our motion to sever the charges.
That's what we were using him for, that, but we were also sending all the blood trail to do the recreation as well. So I don't know what
he never got to that. I was actually reviewing our emails to and from last night because DB was like, "Hey man, send me whatever you got on Turvey." I'm like, I'll ask Allison if we still have our report that he did that we used.
We absolutely have the report.
Yeah, like we should do a live on it, because Turvey's hot right now. Like people are like, because Turvey is in Idaho 4. He was hired as an expert by the defense in that case, and recently had challenged the defense attorneys, saying that he was shocked and surprised and a little bit mortified that they had not attacked the chain of custody of the most important piece of evidence in that case, which was the sheath. And, it was his estimation that the chain of custody was so spurious that it was a huge, huge blunder by the defense not to challenge it in order to try to keep that piece of evidence out. And Ann Taylor fired back. She drafted a letter which she, released to the public, saying Brent Turvey doesn't know how to practice law. He doesn't understand how collection by law enforcement goes. He's just popping off. So there's been this battle going between the two of them. And Ann was like, he signed a confidentiality agreement. He wasn't supposed to be talking about any of this stuff out of school. So yeah, that's
he must have felt compelled enough to violate that to say something.
Yeah, I mean, or he was just trying to get out there in these streets.
Yeah, but nobody wants an expert who violates a protective order. So I think
maybe they do.
Maybe they do.
Maybe they do. I don't know. It's one of those.
So you did tell people that you're talking about Idaho 4. Right?
Idaho 4 case. Yeah, we're referring to the Idaho 4 case, which Koberger's done. Like the only shot he's ever got of anything ever happening is post-conviction work. Any thought of him being able to attack ineffective assistance of counsel at this point, not being post-conviction, is dead in the water, because he waived his right to appeal when he pled out. But I mean, he does have the ability to come with a post-conviction petition at some point, and in which case, you can certainly raise ineffective assistance of counsel in that situation. So, I mean, it's one of those cases that just will never, I am absolutely positively convinced that the Idaho 4, I don't need to check into it, Ovechkin, in the sense that I'm pretty confident that Bryan Koberger is the guy who did it. Yeah, I just am. I get, I think there's a misconception by the general public about how police investigations and crime scenes are processed, and that you are never in the history of the world, no way, going to ever find a completely clean police investigation and processing of a crime scene. It's just, you're dealing with human beings. It's just not how it works. And that's where we live as defense attorneys. We're constantly picking and nitpicking at those things, right? Because there's always going to be mistakes that were made.
But those are issues you raise on cross-examination to challenge the credibility and the evidence, and could it have been tainted and contaminated? But it's not typically like a motion where you just get the evidence completely thrown out. I mean, obviously would depend on the circumstances, but you know,
Yeah, I don't care. I don't care if we lost 23% of the audience because they think that Bryan Kohberger didn't do it or he had help. They're allowed to have their opinions just like I am.
I mean, he might have
And
had help.
I mean, I guess.
We've got no comment on that because
Yeah,
from the
I
jump, we were
wasn't
like,
there. I
right,
wasn't
but
there.
from the jump, we were like 4 people, 1 guy, that amount of time. We
was
were
quick.
like, yeah, we were
Fast. It was very,
so
very quick.
yeah. I mean, I it still seems to me like he would have had help. It just seems like a lot.
It would have been one thing if everyone would have been dead asleep. Then it wouldn't have been that difficult to understand how he could have done it that quickly. If there's people that are awake and he's in fights with Ethan and, you know, there's struggles going on, you know, I mean, it's kind of like when we think back about Garcia, you know, we challenged the time that it would have taken to, and that was 2 victims.
Right.
You
But
know,
also that the state had initially said this had to be 2 people. I mean, I don't know if you got it in the podcast because I actually forgot that you said a new episode dropped and didn't listen to it last night.
this
But
is an
there was
interesting fact.
yeah,
That's a pretty interesting fact.
does suggest more than 1 person.
That is a pretty interesting fact.
So but what I was going to say was that I don't remember. Brain fog.
Something about Garcia. I dropped the
that
episode.
somebody was looking through a magazine sitting in that house. Remember bloody fingerprints on the magazine? Like, what was going on? It makes it seem like there was somebody already in that house before the person that Paul Medine saw at the door. And I don't know if that was ever anything that you guys got into at trial or not, because I was stuck doing my own trial around that time. So
Yeah. Yeah, it's interesting. Yeah. In case you didn't know, that happened yesterday. AO. Richard Allen was granted the oral arguments November 21st of this year is when they go down, 10 a.m. Eastern time. And we're anxiously awaiting that. And they did give a bonus 10 minutes to each side because typically it's 20.
nice.
They gave each side 30. So, I mean,
They're anticipating it being the serious consideration.
yeah,
You know?
I mean, like, because people were asking on Twitter or X, they were like, you know, do you take anything from the fact that they granted the oral arguments this quickly? Like the timing of it to me wasn't surprising. The fact that they gave them the extra time was more telling than the timing of them granting the oral arguments. Because, I mean, look, it's fully briefed at this point. They're moving on it. They've already selected the panel. The judges are who they are. Again, you know, Kara, I had text Kara. She didn't hit me back up, but Osbrook did. And, you know, because I was asking about the panel because they're both familiar with the judges. And, you know, Michael was pessimistic per usual, but realistic. And, you know, it appears that Kara was her typical optimistic self. She's always optimistic, which is nice. It's nice to have that person that isn't so jaded that, you know, by having suffered gut punch after gut punch for decades, you're just like, oh man, you know, it's like but like a majority of judges take the prosecutor track, which is something that I detest. I hate that it's all former prosecutors on the bench. I wish it was more evenly divided. I don't know why more defense attorneys don't try to get on the bench. Maybe it's, I don't know. I don't know what the answer to that is. I'd actually like to do some kind of study to see why more defense attorneys either don't try to get on the bench, you know, because that's a different thing, whether they're appointed or elected, and that's jurisdiction by jurisdiction. So I don't know, but it's a curious thing to me because, you know, you hope that judges go in there without any kind of preconceived notion and bias. But, you know, if you spend 30 years as a prosecutor, that's where your brain is. It's like the same thing that we're always talking about. You know, we look at everything through an attorney's, defense attorney's lens because that's how our brains operate, you know? So it's, you know, and it's the same thing for anybody. You know, if you're trained to think in a certain way, that's how you're going to think and look at things. So, you know, but I mean, there's been prosecutor judges where I felt that they've gone to great lengths to show that they didn't have that kind of bias. even to the extent where, I thought they were kind of favorable to us. Like one judge in Kane, like towards the end of when I was practicing, heavyset guy, former prosecutor. I thought that you had him for a couple of cases. Dark hair, you probably won't. But he made it to the bench pretty, in the last 7-8 years. And I thought that he was pretty even-handed, frankly. So, it's person by person thing.
All right, so we'll call this in the timestamp Richard Allen digression.
Oh yeah.
So returning to what I was saying about Austin Drummond is that, he might be able to get some help with blood droppings, like, because if someone's shot, then the way they were moving or where they were standing, and then where the other, discharged firearms are going, or, rounds, whatever you call them. But those things aren't as easy as it seems on TV. We have learned. So, I mean, it's not really like they're able to actually necessarily figure it all out. And you have to hope that they took really good pictures and swabbed the blood from every spot and, which leaf had which blood on it. So, I can't remember what else I was saying on this, but let's just move to the questions that people have. So first, we want to thank Lucy.
I always want to call her Lucifer, because that's basically what it seems like. It's like a little, little funny,
Yeah, it
little
is.
play on it, so.
Okay, but thank you
so
for
much.
your generosity.
Yeah, we do.
And we don't have this issue with AIM Miss, because she put it right out there for me. But 11 months. Thank you for your continued support.
Thank you. Thank you.
Atheist Ant. Yeah.
Sounds right.
Okay. Good morning. Can we please have a case recap? I saw that and I did that. Thank you. And
Thank
thank you for WB Bob. What's WB?
Welcome back.
Oh.
Oh yeah.
Welcome back. Welcome back. Welcome back.
Oh yeah.
Oh shit. Don't forget, when we get, I don't know if Anne's even in here, but we have to sing her happy birthday. So when we get to the end.
Is Anne here?
I haven't seen her reminding us that it's her birthday. She's like, those assholes.
Oh,
I'm not coming on Friday.
Oh
but
boy.
She'll have to catch it. I hope that doesn't get us
It doesn't. I've played it many, many times.
All right.
Fear
Hope,
not.
who that's my middle name, actually. Allie, we love your pretty face and legal breakdowns. Fan from Michigan. Well, thank you, fan from Michigan. But funny story, while I'm sitting under these lights getting made to look so much younger, my phone didn't recognize my face. So
That's hilarious. That's hilarious.
Oh boy.
I can tell you with great authority that Allison's just as beautiful in real life as she is on the tubes.
It's a little less.
Facts.
Little help here.
Facts.
Then we've got Miss Rattle, member for 5 months. Thanks for your continued support. Has a pro se criminal defendant ever actually won? Well, I looked into this, and it seems that there was in 2008 one murder case where the defendant, who put on no evidence, didn't do anything. I mean, it's just a reflection of how bad the state's case was, who won. But short of that and a couple people getting off on like littler things, I think no. I don't think there's ever been a murder case. But I don't know that the interwebs would have every scenario out there. But no, it's a horrible idea. It's the worst idea we've ever heard. And I mean, you guys were all in the chat saying like, and I think I highlighted somebody's comment that wasn't, let's see. I thought I did. Maybe it wasn't a super. So I meant to highlight this comment, and maybe I didn't because I'm not seeing it right now, but someone made the comment like, I absolutely hate the crime that this guy is accused of committing, but and even if he committed it, something like that, like she still wants him to get a fair trial. And yeah, sorry, I thought I put that in my start it, but I didn't. Dr. Russell's gasp. Member for 12 months. Happy anniversary.
Happy anniversary to you.
Happy anniversary.
Happy anniversary to you. All right.
Yeah. See, this is
Oh,
why
yeah.
we can't sync shit up.
Oh, yeah.
And thanks for your continued support, Dr. Russell's gasp. VDub 725. I'm so lost. I haven't been following this one, but I'm here to support my favorite beautiful humans. So sweet.
So sweet. So
Hopefully we
sweet. Thank
updated you at this
Peanuts.
point. GA Cat Mom. I'm the only one that uses it, but check your Apple sometimes. Love you guys. Check your Apple, babe.
I did, and I responded in chat, and I do get them. There's no way for me to respond in an Apple Pay. Like with Venmo or Cash App, I can always write a little message, heart it, say thank you. But we have received them. Thank you very much.
And make sure you're checking that, and we're thanking her on the, on the
It's
corresponding
weird.
lives.
I don't get a thing.
You don't get a notice. You have to like go into the bank account kind of thing. Is that what you're saying?
What?
I was saying like you don't get a notice. You have to like log into the bank and look for it.
Yeah, it has to. It shows up like as a I don't like. Sometimes when people pay,
It comes to
I'll
your
get a
phone.
text,
Right?
and I'll get an alert. But for the Apple Pays, it hasn't been. I don't know. For this month.
Tabby LH, thanks for your generosity. She says, thanks for all you do. Love the two of you. Well, thank you. And Birdman says, happy Friday, and thanks for covering all the things about the Chicago meetup. Is there an entrance fee? Is there a dress code? Would bringing a small gift for you and Runkle be frowned upon? Will there be toilet wine? But before Bob answers each of those questions, I'm not going to be able to make it because I have promised to help prepare our 2-year-old granddaughter's birthday party, which is the following day. So you will have Bob and Runkle, and I'm sure it will be amazing in all ways.
Oh,
There's
yeah.
no entrance fee, right?
No. So the answer, I did answer in chat as well.
Oh.
So the answers are no, and then no, and then no. And then I said, if you consider Malort to be a toilet wine, then yes. So there's your answers to that.
All right.
So, yeah, I have to force Ian to have a shot of Malort. It's a Chicago tradition. You can't.
I'm sure he'll bend to the will.
Yeah, I'll bend to the will. He fears nothing. He fears nothing. He fears no booze.
Viper asked, hype on reruns, right? Yes, when you are watching on rewatch or after it ends. See, that's the downside, babe. We asked for all these thumbs up during the live.
Yeah.
And then you know what you can do? I've done this before, so I'm pretty sure it works. I'm almost 100%. Undo the thumbs up after the live. After it ends, got to wait like a minute or so. Undo it, redo it, bing, bang, boom. I'm pretty sure you can hype.
Oh, so is that what the thing is? If you've liked during the stream, you cannot hype after the fact?
So Bob doesn't know because he can't hype his own videos under
Right.
Defense Diaries.
Right.
So when you click the thumbs up, it says, would you like to hype? So that's the only way to get the would you like to hype message.
Oh.
So for all of you super fans out there willing, when we end, just go back in. Unlike it, I think you might, like I said, have to wait a minute. Unlike, and then immediate relike, and you should get the hype message. Oh, we've got a workaround, babe.
That's solid intel.
I hope it works.
That's
Otherwise,
solid intel.
blame perimenopause brain. But I'm like 99% sure I did that before.
And I know that you cannot hype during a live.
No,
it has to be after it's over.
I've never seen it anyway. If any of you have, let us know. Priscilla Thompson says, being railroaded just like Richard Allen. Very possibly. Very, very possibly.
Different case, but,
Yeah.
a lot of the same, earmarks that you see with railroad jobs were, but I frankly, I was very pleased with the judge and his admonishments to Austin. I think he was really very, and I mean, it's serves two purposes. Obviously, he doesn't want it coming back on appeal because he didn't properly admonish him in terms of that concept of
No, it
representing
seemed
yourself.
heartfelt, though.
It did. It did. I mean, he was like, man, you fucking up here, kid.
He's like, I'm begging you. I'm pleading with you. I mean, he used his soft, like, I care voice at that
Yeah.
precise
I
moment.
heard you mentioning that. I was sitting right in the chaise listening. So
Okay. And he was trying to bring attention to the live. He was creating content, as my man does, and he is so good at. Fire lawyer, member for 24 months. Happy 2-year anniversary. We greatly appreciate your continued support and generosity. In over his head. Yes. I mean, absolutely
no
yes.
question.
And Amber has the same question. I'm screaming in my head, and I'm sure all of you are screaming. I don't understand why not just request a new attorney. This is what I don't understand. He has an attorney on his other case that he really likes. You need a death penalty qualified attorney, and his attorney in that case is not death penalty qualified. But I think
Look who's here, babe.
Hey, don't when we
Hey.
get to when we get towards the end, I'm gonna run upstairs. Bob will finish the supers, and we're gonna sing to you. So don't go anywhere.
Stay
Almost
here.
birthday girl. I think it's
Stay
tomorrow.
here.
So happy day
Tomorrow.
before your birthday day.
Yes.
Wait a minute. I swiped on the comment line and immediately let me hype. No need to unlike.
What?
Well, she knows something I don't know. You did that while we're live or on a different stream?
Wow. Bad intel.
Yeah. And I just want to correct something real quick. So for that aggravated robbery, the robbing of the convenience store or the gas station, whatever it was, he was 16 when it happened. He was 17 when it was sentenced, and he remained in I believe juvenile jail until he was 18 and then transferred to adult jail. But if you had actually been tried as a juvenile, that's it. You're 21 and you don't go on to big boy prison unless something new happens. But thanks, Ann. And then we've got I don't know, what do we have? Call me Murdoch.
Mamange.
Call me Murdoch. New member.
Have him call me Murdoch. Yeah.
What does Murdoch get?
Family hug.
Thank you. I was just checking if we were getting close. Mermaid Mary RN, member for 5 months. Thanks for your continued support. Thanks so much for covering this, Allie and Bob, from your chaise, babe.
Our pleasure. I was still working.
I know you are. I tease. All right. Kristen Vasquez, member for 2 months. Thanks for your continued support. Says, have you tried Action News website? I did. And I did again after you said that. It prompted me to check a couple of different places, but I appreciate the suggestion. But yeah.
Indeed.
D Nice. Thanks for your generosity. Thank you to all the mods in here. You guys do a great job. And especially thanks to Sharon. You rock. And yes, I gave a special thanks to Sharon before you were on, babe. I don't know if you heard that part. Because I was explaining how I was like I was logged in as you. Which we still have never figured out our family plan, and I refuse to separately pay for a membership. So I'll log in as Bob when I'm actually listening to something on YouTube, like at night in bed. So in any event, I thanked her as well for the timestamp stuff that you told me. Yeah.
Yes.
Sharon
And
does that.
I want to remind everybody that the mods have their own Buy Me a Coffee, which hopefully one of them will drop in the chat. If you guys ever want to give love to the mods, which I highly, highly recommend and would be very, very, very thankful for you doing, you can send them your own little love notes via Buy Me a Coffee. I think they elected to buy me a slice of pizza.
Yeah,
You
that's
can
way
get
cooler.
whatever. Oh, there
Anyway.
you go.
I'd rather buy me a slice of pizza.
Give me a slice.
I'll take a slice.
I need a slice. Give
Not
me some
not
pie.
like a small Chicago square, but like a big New York,
Yes.
diamond, rectangle, square. triangle.
Right. Exactly.
Oh boy. Yeah, one of those squarey triangle things.
Oh yeah. It's a
A
slice.
rectangle, square, triangle.
All right.
Um,
On your ass up here. so
I
we
will.
can
I
do
just
the
wanted to
birthdays.
say the Spitfire Dragon says enough. Gannigus wants a Team Allie has your back shirt because he loves Allie. LOL. I think we should do that, babe. I think we have Spitfire's address somewhere from other things. I mean,
I
Gannikus.
still might. I think I have one of the boxes because Spitfire sent us many gifts over the years.
No.
The one that has all the masks in it. I think I still.
All right, then.
I hold the masks in the box you sent it in. So
Do we
I'm
have
sure
a shirt
she'd
that says
happily-
that?
Huh?
Do we have a shirt that says Team Allie has your back? Team Allie.
I don't know. I think it says Team Allie has your back.
Okay.
I don't know.
And I hope
Gannigus
Gannigus
putting our
really
merch
liked
store up. No.
really liked his cheesesteak. I'm hoping the answer was he liked it so much he wanted to travel to Philly for a real one, and not like he was so meh about it. He wanted to travel to Philly to get a good one. All right, go to Cody in Tennessee, and I'll come join you for Ann's birthday song.
All right, Cody in Tennessee, $5 says, thank you for covering Drummond. You guys are the only ones covering this. I just think there is something fishy about this case. We feel the same way. We do. There's something weird about it. There's something off about it. I can't quite put my finger on it, but we agree, which is one of the reasons. Like, we typically try to pick cases where something seems a little off. I mean, obviously we cover cases and trials that are up that, seem pretty straightforward. I mean, Corey Richins, seem pretty straightforward, and multiple other trials. But in terms of cases that are not being streamed or are being litigated and it's pre-trial and I catch wind of it and it seems like there's something strange going on, those are always the ones that really catch our eye. So but we appreciate that. And thank you so much for the 5. The Goodman 4431 member for 11 months. Looking forward to watching this trial with you two. Well, we'd love to hear that. And we love that you'll be here with us. Thank you. Thank you. Thank you. And thank you for being a member. Giggle Glimmer 1 member for 12 months. Thanks for the recap and the coverage. Love, DD fam. All right. Thank you guys for all your generosity today. Oh, and of course, our Venmo angel, Kim.
Thank you, Kim.
Once again, dropped another 25 on us.
So generous.
I mean, I feel like we're like a monthly bill at this point for Kim. So I'm
daily bill.
Daily. Well, but I just calculated by at the end of the month. I'm like, man, like Kim, she's real hero status. I'm going to have to make a Kim shirt. And I never see her in chat. If she is, I don't know who she is. She's like a mystery benefactor that just hides in the shadows and showers us with cash. So, and we're super grateful for it. All right, you guys ready for Ann and the wonderful Ann Piccolo, who's been a super OG. She's been here for as long as we've been a channel. I think Ann was a OG podcast person. So it's her birthday tomorrow. So everybody start wishing Ann a happy birthday because we're about to break it down. Ready? A 1 and a 2 and a 3. Happy birthday to ya. Happy birthday to ya. Happy birthday. Happy birthday to ya. Happy birthday to ya. Happy birthday, Ann. We love you.
Ann, and anyone else whose birthday it is.
Yeah, for all those who have a birthday up and coming, we love you all. We hope you have a wonderful day tomorrow, Ann. I hope you were celebrated the way that you should be. Ann, you're a big baseball fan. That's correct, right? You're like you don't talk about it here, but I think it's you that's a huge baseball fan. I can't remember if it's Ann. There's one of my longtime followers loves baseball, and they're always talking about the Reds. So I don't know. I'm sorry if I'm confusing you with another person. There are 2 people that really love baseball. So, but we love you, Ann. We hope you have a wonderful day. If it is you and the Reds are at home, I hope you get to go to the game. Nope, not baseball. Wrong person. Damn it. Who is that? Now it's going to drive me nuts. I'm going to have to scour my Twitter and figure out who it is. It's another long timer. Yep. Cubs, White Sox tonight. should be good. The Sox actually don't suck.
Ooh, that's exciting.
Surprising. Yeah, I've disavowed myself from watching them for the past 2 years because they've been so horrific. All right, you guys, we love you so very much. Mods, we adore you. We couldn't do it without you. We are so grateful to you. Every single live, you're here for us, and you guys are the ones who make the community what it is. So thank you for all your hard work. And for all of you, old and new, make sure you like, share, and subscribe. And just know in your heart, deep in your hearts, that if it wasn't for you guys, I'd literally just be an old man
Sitting around talking to his wife.
Boop.